Yes, sir, admission.
Land acquisition matter. Land acquisition placement.
Pardon to make a mention, Your Lordship. Lordship, in today's list, item 59. Lordship, this Honorable Court had issued notice by order dated 3rd of October 2024, but no counter has been filed by the opposite party, Your Lordship.
Who is to file the counter? Opposite party, who is?
Union of India, Your Lordship.
Okay, Mr. Padhi.
Yes, we have sought for instruction. I didn't receive the from GAL is employed as a party.
Item number
59, Your Lordship.
Item number 59 is mentioning Mr.
Oh, sorry, sir. I am from the
What is with you? Cause list.
Yes.
That is
Nirupama Naik.
right.
Yes.
So, what order was passed?
Nirupama Naik कौन है? Nirupama Naik 59. Nirupama Naik 59 postal लग सकता है. कौन है? एज की इंस्ट्रक्शन क्या है? जजमेंट मांगे सुप्रीम स्पेशली ready received valid did not receive. Okay. So if करना तो 59 करना.
What about the private opposite parties? There are 4 private opposite parties. I'm not looking for plus 10, 7 down, plus 10. With order, these are counted.
हाँ ये जो private opposite party 7, 8 all are private opposite parties.
Not received. What about the other opposite parties? Six is Devasriya Revansha Naik. 6 ର କିଛି noting ଅଛି order sheet ରେ? It is received valid service है it is not received from 7 and 8. 7 and 8. ତାପରେ ଗୋଟେ valid service ହେଇଛି. It is received from so and so. The opposite party number 8. Let's do that. So here, Mr. Padhi, in this item number 59,
My lord.
You are appearing for 1, 2, 3, and 4, right?
Yes.
For us, 5, 6, 7, 8.
7, 8 all are private opposite parties.
Private parties. 5, 6, 7. That the notice has already been served. Valid service is there. So,
my lord.
Then, so far as 8 is concerned, AD not written. So, have you filed your counter affidavit in this case?
No, my lord, we have not filed the counter. We are supposed to file the counter affidavit.
Item number 59, WPC 2501 of 2024. It appears from the notes placed by the registry that there is a valid service of notice on opposite parties number 5, 6, and 7. Stop. The AD has not been received from opposite party number 8. Stop. None has appeared for opposite parties number 5, 6, and 7. Stop. If any Land and Council enters appearance for the aforesaid opposite parties. The VNAMA be placed on record and their names, the names of the Land and Council be reflected in the cause list. So far as opposite party number 8 is concerned, necessary instruction be obtained from the postal department by the registry regarding service of notice on the said opposite party. Stop. Mr. P.K. Pari, Land and Deputy Solicitor General, along with Mr. D. Gochad, na?
D Guchayat,
Mr. D.
Deepak
Gochad,
Guchayat.
Central Deepak Gochad, Land Central Government Council, seeks for some time to file the counter affidavit out of this matter in the so and so. January 2nd week, Rasu.
Again,
All right.
Well, it is it for your lordship. May I make a mention, ma'am? The criminal appeal of 2019. Today,
Appeal.
criminal appeal, ma'am. The person is in custody since January 2017.
Want bail application?
Yes, ma'am. The reason is today in the morning I received a call from his villagers that his daughter passed away at 1 o'clock in the.
No, it's all right. You file a interim application.
I have filed, my lord, today. I have already filed. If your lordship may kindly take it up at 2 p.m., my lord, if you
Please file the memo
Well-
and also the interim application. We can take it up. All right.
Your lordship may take it up today, my lord.
Mr. Counsel,
Well,
are you not able to follow us?
I'll file it.
File the memo, file the interim application, then can we take up? Okay.
Lordship, with permission, one item number 41, my lordship.
Yeah.
In the item number 41, I am for the OP number 4, which is the auction purchaser, my lordship. The matter is pending since long. The borrower has preferred an appeal against the order passed by the
All right,
DRT.
we are going serially, we'll see that. Yes.
My lordship, there is a direction from the Supreme Court also, my lordship.
All right, we'll see. We are going serial. Yes. Next.
Pardon to make a mention, lordship, the trace admission matters are this. Would like
My lordship, with permission, just one thing, my lordship, that item number 41 is getting listed daily. It is not reaching, my lordship. May kindly hear the matter, my lordship.
Yes. Item number 1.
Obliged.
Weekly list item number 1.
Viewers, there are challenged the notification for using the land under the Petroleum and Mineral Pipeline Acquisition Right to Use Act, my lord, 1962.
You have filed the corrected cost item?
Yes, my lord, I have filed.
Okay.
And the annexure
What
for
is
my
your prayer?
objection,
What is your prayer?
try to close the notification, my lord.
Questioning of notification, 3-1 notification.
You have filed your objection
Yes, I have already filed my
on
objection.
16/6/2022,
Yes, my lord.
and you have been asked to remain present.
Present, I have present, but I have not been communicated with any order.
Mr. Pari. Mr. Padi, item number 1.
my lord,
Have you received any instruction? What happened?
we have not received any instruction, my lord.
He was called for personal hearing as per the notice under Annexure 5, and that too on 8/9/2022. That is Annexure 5. He filed the objection. Objection was filed under Annexure 4 to the notice which was issued for taking that gas pipe line, and after receiving the objection, a date was fixed and notice was issued by Annexure 5. So he said that thereafter he has appeared, but thereafter there is no communication from the authority. So what happened and what is the status?
My lord, I sought for instruction that they didn't given. Lordship give more time. Implicit last occasion, my lord, implicit party.
No, that is complete. He has filed the consolidated cost. Yes, that is done.
GAIL India.
GAIL India, so that is done. So you are to just apprise this court what happened after his objection was heard, because he was
Exactly.
supposed to be communicated with the order, and
My lord.
so take down.
Another 2 weeks time, may you will.
Okay. As per the order dated 5/9/2024, the Land and Council for the petitioner has filed the consolidated cost title which is taken on record. The copy of the same has already been served on the Learned Counsel for the Union of India. Mr. P.K. Pari, along with Mr. Deputy Solicitor General, along with Mr. D.K. Gushad, Land Central Government Council, FES, and 2 weeks time to obtain instruction regarding the communication, if any, made by the opposite parties to the petitioner after he was or she was given a personal hearing as per the notice dated 8/9/2022 under Annexure 5. Put up this matter. Today is 25th, so this matter will come on 16th. Okay. Put up this matter on 16th of
Yes,
December.
16th, yes.
Yes, Mr. Padi?
16th, yes, ma'am.
Okay.
Item 2.
Lord, item number 2, my lord. On a week time may kindly granted to file the objection in respect of the opposite party number 3, my lord. Only 14th 11th 2024 I had received the copy of the read question.
Yes, just
Only a week time may kindly.
Last order, Learned Counsel for the pro forma opposite party number 4. Also, the Learned Counsel for the state submitted that affidavit which has been filed by the petitioner in pursuance of the order dated has not been served upon them. Learned Counsel for the OP number 3 submitted that he has not received the copy of the writ petition. Let the Learned Counsel for the petitioner serve the copy of the affidavit on the respective counsel along with copy of the writ petition on the Learned Counsel for the opposite party number 3. So you have served on
My lords, we have served it on email, WhatsApp on 12th November. Today is, my lords,
I
yes.
am for the opposite party number 4. Already received.
So you have received the copy of
Yes,
the
they have all received, my lords.
And Mr. Sahoo,
My lord, I am
you are
for the
for
OP
which
number
opposite
3, my
party?
lord.
Mother diagnostic.
Diagnostic.
What do you want?
My lord, before the only week time may kindly granted.
Okay, it will come next week. That is
you oblige.
you have to file the counter affidavit.
My lord.
My
Mr.
lords have not
Sahoo,
issued
Land
notice in the
Counsel,
matter till now.
appearing for opposite party number 3, submits that the matter may be taken up next week so that counter affidavit will be filed in the meantime, serving copy on the Learned Counsel for the petitioner, so also the other opposite parties. Put up this matter in the week commencing from 2nd December.
My lords, may kindly keep it after 4th. My lords, there's a wedding in the family.
Submitted by
After
the-
4th.
My lords, after 4th, because there's a wedding in the family. My brother's daughter is getting married.
After 4th. Then let it come
Ninth.
on 5th.
Yes,
The
my lords.
supplementarily
Yes, my lords.
on consensus of all the parties, list this matter on 5th December 2020. Okay.
Oblige.
Yes.
My lords, the only
As a khali lekhi diyantu, the Learned Counsel for all the parties submitted that as per order dated 12/11/2024, they have received the affidavit. What affidavit that was filed?
my lords, an additional affidavit my lords had asked.
Affidavit filed by the petitioner, and Learned Counsel for the opposite party number 3 submits that he has received also a copy of the writ petition. Right?
Oblige.
Item number 3.
And to agree for next week, my lord.
What was the order? Let us see. It is coming for the first time.
It is for first time. Postal matter, man.
Yes. You want next week?
My lord.
All right. What is your good name, Learned Counsel?
K. Badai.
K. Badai, Learned Counsel, appearing for the petitioner. 6 for an adjournment till next week. Mr. Padhi, Learned Deputy Solicitor General, along with
BK Padi. BK Padi. Virendra Kumar Padi.
Virendra Kumar Padhi, Learned Central Government Council, is present. Put up this matter. We commencing from 2nd of December 2024. The Learned Counsel name of Mr. Padhi and so also be reflected in the cause list henceforth. Yes.
Oblige.
Item number 4.
Mr. Amiya Kumar Chatoi. My notation on here is pass over করতাম দেখি
Item 5.
Milord, item 5, Milord, I pray, Milord, annexure 6 is my representation. The same order is also passed in other cases.
Annexure 6.
That may be taken into consideration.
It is the representation to be disposed of by the authority, time limit 3 months and 2 weeks for communication of the order taking the decision. All right, disposed of. Yes.
Item 6.
Yes. Sir.
On behalf of everybody, good to Kora. I take instruction on after matter task.
Let us see that order which was passed on 1811. Please see Pilakura Nasi. Computer bar करेंगे तो क्या आउट ऑफ पढ़ाएंगे Mr. Naik, please assist so that they can find out the order dated 18/11/2020.
Here the State Bank of India was to Mr. Gurudat Kaura is the
Sir, account is something that one of your so instruction is solid again.
When you are coming to take adjournment, you should not only read the brief, but you should also go through the last order or the orders which have been passed. It is for the betterment of you, which you are a young counsel. Read the order dated 18/11/24. Otherwise, simply taking adjournments will not help you to develop in future, right?
Has filed this petition challenging the action of the opposite but no one.
Which are you are pressing the, this is the matter, item number 6, order dated 18/11/24.
This matter is taken up through.
Please come next sentence. Next line.
The petitioner Sitaralla has filed this writ petition challenging the action of the operator number 1 and 2 in sealing the house of the petitioner illegally. Law and counsel for the petitioner submits that the petitioner purchased the property from operator number 3, Samir Kumar Patra, by way of registered sale deed dated 4/3/2020, and thereafter necessary correction has been carried out in the ROR by the annexure 3, and he was paying rent for the land in question. When a query is made to the Law and Counsel for the petitioner as to whether the opposition number 3 has availed any loan from the State Bank of India keeping the property purchased by the petitioner on mortgage, he submits that petitioner is not aware about the same. However, from the sale deed in clause 3F, it appears that if the purchaser is deprived of the house and site thereby sold by reason any defect found in the title of the seller or of any incumbrance charge or claim on the same, the seller shall pay to the purchaser by way of damages the whole amount of sale price and the amount spent by the purchaser for construction or anything else whatsoever, if any, with interest and litigation costs from his other properties, besides being personally liable. Law and Counsel for the petitioner submits that Mr. Gudadakara, Law and Counsel, usually appears for the State Bank of India. Let's copy of the petition along with the enclosure be served on Mr. Kora during course of this week, so that he will obtain instruction by the next date.
Okay, so have you served a copy? Yes. What is your instruction?
Instruction not collected from bank. Manu Capras. Sir,
The Law and Counsel for the petitioner submits that as per the order dated 18/11/2024, he has already sought the copy of the writ petition on Mr. Gurudatta Kara, the Learned Counsel who usually appears for the State Bank of India. Stop. What is your good name? Vikas Kumar Padi, associate of Mr. Gurudatta Kara, advocate, submits that instruction has been sought for from the bank and the matter may be taken up next week. Put up this matter on in the week commencing from 2nd of December 2024. Instruction be obtained by the Learned Counsel for the State Bank of India in the meantime. Yes.
Yes, I'm serving a copy of interim application for
IN number 14942.
IN number 149 ମୁଁ କପି ଦେଇ ଦେଇଛି ସେଟାରେ ଥାର୍ଡ ପାର୍ଟି ରାଇଟ୍ କ୍ରିଏଟ୍ ନବା ପାଇଁ ଆଉ ଗୋଟେ ଆଇ ଫାଇଲ କରିଛି ଘର ଖୋଲିବା ପାଇଁ
So what is the number of that I?
ମୁଁ ଆଜି କପି ଦଉଛି ନମ୍ବରଟା
Acha, the Learned Counsel for the petitioner submits that the petitioner is intending to file an interim application during course of the day. If the said interim application is filed, it may be placed on record and a copy of the interim application be served on the Learned Counsel for the opposite party. Yes.
That's something.
Maybe.
Item number 7.
The direction you giving the authority opposite to number 2 for approval of benchmark valuation. Annexure 5 and 6 present.
Independent.
5 is the 5 and 6.
Five and
5.
Who the representation?
5.
John officer.
5.
Panchata.
My lord.
Panchata won't be.
John
Annexure 5 to dispose of karibe. 3 months or 2 weeks for the usual order.
Panchata all the villagers is there.
Huh?
Annexure 5 tare villagers man sign korchandi.
Sobhakar Naik is 5th position. Sobhakar Naik, present petitioner.
But 6 re
Annexure 5 si chauchandi or kon?
Annexure 5 and 6.
Sorry?
So,
ପଚାରୁଛୁ କୋଉଟା ଆପଣ କହିଲେ annexure 5 ସିଓର ତ ବର୍ତ୍ତମାନ
Annexure 6 କରିଦିଅନ୍ତୁ.
annexure 6 to be disposed of. Yes.
Item number 8.
May I please? In the instance case, the land acquisition award has been passed, taking into account the Dongar 1 land, whereas disregarding or ignoring the homestead land of the petitioners, wherein the house of the petitioners are there and it is the only house. The conversion fees has also been given under Annexure 2 series at page 22. 30,000 something 30,000 and 252 has been given in the year 2022, and the land acquisition award has been passed in this year, that is in 2024.
No, you are challenging annexure 1.
My
Okay, please come to annexure 1. Let us see. Which order you are challenging? Because there are a number of orders in that annexure 1.
Challenging particularly the Dongar land.
No, 7 to 24. Which order is under challenge?
There are 3 orders in that annexure 1.
7 to 7-3
and 23-2 also. So which order you are challenging?
Page 12.
Page 12.
Mine.
So 7 to 24 order was you are challenging.
Mine.
So thereafter subsequent order has been passed as it appears.
Subsequent order has been passed.
So 7-3-24 order you are not challenging.
Now all these under annexure page. That is
Oh, so you say that is
please see your, Mr. Counsel, please see your prayer.
Mine.
Your prayer is you are challenging the order dated 7-24. Please see number 3.
And 24 was the order.
And next was the order dated 24-9-20. Right. So if we come to that annexure 1, we find that apart from 7-2024, there is another order which is dated 7-3-24. So
last order is page 17. Last order.
Page 17.
Liberal option.
No, 1824.
No, 180.
180.
So you are very much present on that day, on 1/8/2024.
On 180, you said that we were present.
So
But it is the honor my impression that the homestead land the calculation will be made as per the my homestead land. But it has been in the page 12 mail. It is the calculation has been made as per the Dongar one land.
we do not know the.
So you made a
You are
representation.
satisfied with the award amount, and
The amount
you-
was directed to a depositor.
that amount was directed, and it is to be paid, and paying with this one. So
He is
whatever.
filing a representation.
So now you are filing a representation
Mine,
on 28/2024 before Collector Navrangpur.
mine.
Have you not received any communication from the collector?
No, it
All
has.
right, communication, Annexure 3 is the representation. No communication has been received within 3 so and so with your order. That is to be disposed of and order be communicated. Yes,
May I pray? My lord, answer 4 eviction notice has been issued.
So
all right. That you will take care of.
I pray that this may be may not be acted upon till
No,
the
we are not going to hear, sir. Yes.
Item 9.
Yes, Mr. Moon.
Please, my lords. My lords, in item 9, all are covered matters, my lords. I have
Where is
annexed
order?
annexure 3, my lords. Page
Annexure
number-
3.
Yes, my lords.
Annexure 3 is what? Is a order is what? Our own.
Acha, so without
24
expressing anyone. This court dispose of this one so directing the OP number 3 to dispose of the 28A application arising out of in accordance with is a case number उड़ा के change होगा.
My lords, I have the corrected copy, my lords.
अच्छा अच्छा सबू केस में दे दीजिए. ठीक है. केस नंबर उड़ा का पहले करेक्शन करी गई चाहिए. ये जो ये है आउटर भी तुम चेक कर लो. LAR केस नंबर उड़ा का. Yes.
Item 10. The dispute is one village Uttaraswar under Baleshwar district in Soro area was notified for acquisition. My lord, may kindly turn to Annexure 2, page 10. The notification was made first initially on January 25, 2022. My lord will kindly
This
see.
notice is dated 38/24.
Yes. My lord, notification was initially made on January 2022. In that notification at page 21, my land was not covered.
You Annexure 1 data was latest pra.
Sir, I'll come here later. If you lordship may kindly allow me to see page 21, man. Page 21, my plot was not included in the notification.
Yes.
Thereafter, another notification was made on March 29, 2022 under Annexure 3. There also, my lord, I have stated at page 51, village Uttaraswar was not, my land was not covered. Thereafter, they gave me notice under Annexure 1. Your lordship will kindly see Annexure 1. They have asked me to appear and show cause. My lord, I have filed my show cause under Annexure 5 at page 60.
What happened to that?
My lord, they have not decided show cause. Initially, in both the notifications, my land was not covered. Now,
right. Have you? We are asking you a question that have you, after filing this objection,
yes,
by Annexure 5 series,
my lord,
Did you receive any communication from the authority?
No, my lord, neither communication nor they have asked me to give a personal hearing.
So,
And now they are threatening that I will demolish the structures
who
of
is that opposite party?
my lord, it is my lord, it is land action officer.
OP2.
Yes, my lord.
All right, objection pending before the opposite party number 2. Same shall be disposed of. Time limit be fixed and order be communicated. Yes, next.
My lord.
Item 11.
If I may pray, my lords may kindly take up item 19 along with this. Item 19, my lords, is a better case. Why I say so? There we have received a notice for personal hearing pursuant to our objection. However, till date, no such decision whatsoever has been taken by the OP number 2, my lords, on our objection.
Yes,
My lords.
19.
Yes, my lords. This is for land acquisition.
What is your prayer?
This is for enhancement of
the compensation in terms of the market value of the property.
My lords, we have made objections via Annexure 3.
After filing of the objection by Annexure 3,
We
you
have
are given the notice for personal
hearing.
So that was when? What is the date?
Exactly, my lords. The date was not mentioned in that.
So 2020 ଉପରେ ଲେଖା ହେଇଛି.
Yes, my lord.
So ଆପଣ କଣ କରୁଥିଲେ?
We filed. That is what, my lords. These are poor villagers, my lord. They were not aware of this.
Have you received any further?
No, my lords. That is all. The Annexure 3 has been pending since then.
All right. After filing of the objection under Annexure 3. Yes. You are
NHI.
Here, my lord, land has been acquired under NH Act, my lord. But it has been executed by state government. He has come prayed for enhancement of compensation. There is a specific provision in the NH Act under section 3G5. He has to approach the arbitrator or collector.
That is correct. But there is also a provision for objection stage.
But there is no purpose. Anyway, objection.
But NHI is not a party.
Yes, if the OP2 needs to consider
objection has been filed, Annexure 3, and a notice of personal hearing has been given. You attended the personal hearing?
Yes, my lords, but
petitioner attended but thereafter no communication has been made. The opposite party number, who is the opposite party? 2.
Tahsildar come land acquisition officer
shall communicate the order passed in the objection to this one, so within periods mentioned dispose of. Yes, next.
Item 11 and 19, my lords, both.
19 and 11.
Yes.
19.
Okay. Yes, next.
Deeply obliged.
Item 12.
Item 12, we have filed the memo, withdrawal memo, your lordship.
Item 12, withdrawal memo filed?
Yes.
Disposed of as withdrawn.
Item 13.
May I please, my lords? My lords, item number 13, 14, 15, and 18 are similar to item number 9, my lords.
Okay, disposed of.
13, 14, 15, and 19.
18.
13, 14,
15, and
14 and 8. 13, 14, 15, 18.
Disposed of. Yes.
My lords, I have the corrected copies.
Yes, yes. The corrected copies. Even correction for the outer number.
Item 16.
Yes. 13, 14, 15,
18 minutes.
16.
13, 14, 15, and 18 minutes.
Right.
16.
Item 16.
May I please, my lord?
Yes.
My lord, here the petitioner is running his business over a government land, my lord. And my lord, after the threatening from the opposite party number 3 to evict him, he had made a representation before the collector of his opposite party number 2.
Have you received any communication from the?
No, my lord. They have only came. They said that you will vacate the land because.
No. Have you received any communication on your representation?
No, my lord. Nothing, my lord. That is pending. Annexure 3.
27/8/24. Your representation date.
Yes, my lord. 27/8/2024.
To be disposed of and communicate the order to the council. Yes, next.
Deeply obliged.
Item 17.
Yes, Mr. Bhuiya.
Item 17, my lord, I have on the behalf of the bank.
Who is appearing for the petitioner? So appears. Have you taken instruction on it?
Yes, my lord, I have filed Waklan Nawa.
No. What is your instruction? What is his prayer in this writ petition?
There are 4 accounts, my lord. They have not been made payment since long, my lord.
Yes, the petitioner shall not so and so given in the light of prevailing samjhota outreach by the opposite.
We have already started the action process, my lord.
Seat for negotiation. So you asked that for to have an amicable settlement. So have you made any communication?
No, my lord. We have started the action process, my lord.
Oh, you have already started?
Yes, my lord.
Paper
Paper
notice
publication
has been issued.
Yes, my lord.
Where is that notice? He has not.
Next is 18/10/24.
18/10/20. Position taken, symbolic position. So after that, what you have done? 13/4 notice issued. You have gone for auction of this.
Yes, my lord.
Whether it has been finalized or still?
Yes, we have already made the paper publication and also obtained the DM permission also.
Section 14.
As per the section 14.
Section 14,
Yes.
that means it has all right. Look, non-appeal for the petitioner. There. Mr. Sivadatta Ram Prasad Mishra, Land Council appears for the opposite party.
5, my lord.
Opposite party number 5.
The authorized officer.
Chief manager and authorized officer. Which and files VNAMA which is taken on record. This writ petition has been filed by the non-appeals for the petitioner by the petitioner so and so with a prayer so and so. The London Council for the bank submits, opposite party number 5 submits that in the meantime the property has already been put to auction and the auction has been finalized and steps have already been taken by the bank under section 14 of the Surface Act in view of the submission and the ratio laid down by the Honorable Supreme Court in the Bafna Motors case. We are not inclined to entertain this writ petition which is disposed of. The petition is at liberty to approve the alternative remedy. All right, next.
Item 20.
Item 20, as per the order of this Honorable Court, we are already supplied the limitation petition on 7/11/2024.
19 is right now.
19 power is
I'm applying for the opposite party.
Ma'am,
My lord, the
in 19.
20, this is a 20.
That is over.
So
We are already.
there is
the delay is about 300 days. My
no,
lord,
he has served a copy
yes,
of
copy,
the
yes.
interim application.
Yes, my lord, I have received.
So did you?
No, I will argue, my lord. You will submit on that delay petition.
You don't want to file any objection?
No, my lord.
All right.
Because
What is your objection?
objection is that is the communication of the in between the staffs. There is just state is just like individual. Therefore, the communication between them is no ground for continuing delay. And also, my lord, kindly see the annexure of the order has been challenged in this writ appeal. The direction by my lords to correct the error as per the order of the commissioner.
We are not going to that unless we condone the delay.
My lord,
we are not
no,
going.
I am
to
just on the merit of the case. I am just
no merit we will hear once we condone the delay. We will hear the
Well.
merit. IA number so and so is an application for condonation of delay. The stamp reporter has pointed out that there is delay of 304 days in filing this writ appeal. As per the order dated 4/11/2024, the Land Council for the appellant has solved the copy of the writ appeals. Also the
On 7/11/2024.
interim application for condonation of delay on the Land Council for the respondent on 7/11/2024. The Land Council for the respondent has not filed any objection and submits that he doesn't want to file any objection. After hearing the land and council for the respective parties. Going through the averments made in the interim application, we are inclined to condone the delay in filing the writ appeal. Accordingly, delay is condoned, IA is disposed of. The writ appeal will be listed next week for admission.
Right.
Yes.
Item 21.
21, my lord. I am for the bank, my lord. Let's go 1 week after I will file the objection, my lord, in the IMS.
The IA for amendment at the implementation of parties, necessary parties.
Not only parties, my lord, all facts and prayers also.
Okay.
My lord.
The land and council for the petitioners is present. So also the land and council for the opposite parties to seek some time to file objection to the interim applications filed for amendment of amendment. Put up this matter.
1 week after.
1 week time. Is this matter will be commencing from 9th December 2022. Copy of the objection be served on the land and council for the petitioners in the meantime. Yes.
The interim order may kindly consent.
There is an interim order.
I think it's like.
No interim order. No interim order.
Yes.
DRAT challenge करके.
Item 22.
Item 23.
22.
May I please allow?
What is? Yes.
I am for the petitioner, my lords. As per the noting, my lords, notice is sufficient.
Mr. Biswal had appeared last. Then
we
submitted.
No, the stamp reporter pointed out that there is delay of 5 days.
5 days, lordship.
So that is how the notice was issued as per the order dated 5/11/2024, right?
Lordship.
So there are 2 opposite parties.
Lordship.
And what happened on that notice? Notice is sufficient. So who is appearing for Mr. Biswal, Anjan Kumar Biswal?
It is assured to file the Vinama next day. It is assured to file the Vinama next day. We will file Vinama. So also the objection. No. Vinama is only in respect to. No.
But counter affidavit filed to submit.
Lordship, that counter has been filed for IA number 108. That is for stay. For condonation of delay, my lords, my learned senior has not filed.
No, they have already entered appearance.
Lordship.
And you have received the copy of the counter affidavit.
On his way. My lords, he's on his way, my lords.
My lords, my learned senior Mr. Biswal is on his way.
Pass so.
Lordship.
Item 23.
Yes, it is also for amendment of the writ petition. And what is your submission, Mr. Land Counsel for the state? Who has filed this IA for Mr. S.K.Sahoo?
Yes. I have filed the IA.
What amendment you are seeking for?
Copy of Khatian and the copy of order of Honorable High Court. I have inserted attached it with page number 2930 and 3132. Annexer 6 and Annexer 7.
So have you gone through the interim application?
Yes, my lords.
Have you got any objection or will allow?
May be allowed.
IA number so and so. There is an application for amendment. The Land Council for the state has no objection to the amendment sought for. Accordingly, the amendment sought for is allowed. Where is your schedule, Acha? The schedule A is permitted to be incorporated in the writ petition. Let a copy, consolidated writ petition be filed. How much time you want? Consolidated, incorporating all the amendments you want to file?
1 week time.
1 week time. Serving a copy on the Land Council for the state. Yes. Next one. I to dispose of कर देगा ना
I may be excused. I was not there.
Yes, yes. So who is appearing for? You are for the opposite party.
Yes,
sir.
my lord, date.
Huh? You file it. You are given 1 week time to file the consolidated it. So once you file it and serve a copy, it will be listed. That would be the order. Yes.
Obliged.
So this Mr. Vishwan,
Yes, ma'am.
the stamp reporter pointed out that there is delay of 5 days, and so you have not filed your objection. So you have no serious objection, obviously.
No, my lord. No such petition has been filed.
No. IN number 404 of
First,
24
notice.
is the application for condonation of delay, and he has served a copy.
That is not with me. For that reason, I have not.
No.
So I have no serious
All
objection, my lord.
right. IN number so and so is an application for condonation of delay. The stamp reporter has pointed out that there is delay of 5 days in filing the review petition. Land counsel for the bank has no serious objection for condonation of delay. Accordingly, delay in filing the review petition is condoned. IA is disposed of. So, let it come under the heading of admission next week.
Yes, ma'am. Not sure.
Put up this matter under the heading of admission. Yes.
Item 24.
Obliged.
Please commencing from 2nd of December.
My lord, item 24, kindly pass over, my lord. Kindly pass over, my lord.
Well, this were directed in the last occasion, order dated 11/9/2024. May I place that, one?
Yes,
Because the
read it.
instruction.
Please read it, sir.
Yes. The matter is taken up through hybrid arrangement. Mr. Ajudhya Ranjan Das, learned additional government advocate, submitted that he was supposed to obtain instruction regarding readiness and willingness of the state to go for settlement with the petitioner as per the order dated 21/8/24. But the matter may be taken up after Puja vacation so that the petitioner and the opposite parties may be asked to sit together for settlement of the issue and shut out the matter. Mr. S.S. Das, learned senior advocate, appearing for the petitioner, has no objection. So, my lords, that instruction has not come. My lords, we have written letters. If my learned senior agrees, my lordship may take it up next week.
Next week.
Yes.
So the new panel has come, so we have to give some time to them.
My lord, next week,
Yes, some difficulty.
there is some difficulty.
All right, let it come on 9th then.
My lord, let me fix ask date from Mr.
I
Das.
give the date. We'll fix it.
My lord, obliged.
The Mr. Prabhu Prashanna Behera and an additional standing council seeks some time to obtain instruction as per order dated 11/9/2024. With this matter in the week commencing on Madam J. Devi. Yes.
Obliged. Interim order to continue.
There is interim order. Interim order passed earlier, shall continue till now. Yes, next.
Obliged.
Item 25.
I have challenged the order passed by the
Lords, I am appearing online, Lords. I'm sorry, Lords. Lords, in this matter, I have instructions to appear for Nilachal Ispat Nigam Limited. Pursuant to the dismissal process, Tata Steel is now the owner of it. I would request Lordship give me some time to file my Vaklatnama, and I'll try and coordinate with my learned senior's office for a copy of the writ applications.
You have instruction to appear for whom?
For Nilachal Ispat Nigam Limited.
Okay, then for the OP number 2, 3, and 4.
Lords, now it's a private party. Essentially,
okay. Right. 3 is the managing director of that Nilachal Ispat, and 4 is the general manager. So once appearing means you are appearing for all the 3. Have you not received a copy of the writ petition?
No, my lords, I am appearing for the first time in this matter.
Okay.
Seeking clarification.
Mr. Roth.
সেটারও copy মতো যাব।
He must have got it from his the advocate who was engaged because
directly from the
234 had
manager.
earlier appeared.
But I'll coordinate with my learned senior office and try and take a copy from him.
Requesting for another copy. So
Yeah, has he got any associate here so that he can take my brief and get it xeroxed?
I will do it now.
That will be better.
Please do it during course of the day so that he has Mr. Roth has brought it. So whose name will reflect in the cause list today?
My name, my lords. I'll file my Baklatama in 2 days time.
Amit Patnaik.
Amit Patnaik.
Learned Council submits that he has instruction to appear for respondents number
2, 3, 4.
2, 3, and 4, and he will file VNAMA. However, he requests the Land Council and senior advocate appearing for the petitioner to supply him a copy of the writ appeal. Let Mr. Roth, Land Senior Advocate, supply the copy of the writ appeal.
Now, my lords may direct that he is to collect it because I will
let one of the associates of Mr. Patnaik collect the copy of the writ appeal from Mr. Roth, and the matter be listed next week. Yes.
One prayer, my lord. Suppose he wants to file any reply, any counter, anything like that. Let him take that because all that I must be ready for that day.
I will look at Lordship will call it after 2 weeks at least after 2 weeks. In the meanwhile,
okay, the matter be listed after 2 weeks. Counter affidavit, if any, be filed in the meantime. Yes, next.
Deeply obliged, my lords. I'm sorry, my lords, for the inconvenience.
All right.
Item 26.
It's item 26, my lords. We have filed an IAF, my lords. But my lords, unfortunately, I'm sorry, my lords.
26, what is happened?
My lords, there is an IA for clarification of the order dated 6/3/2020. My lords, I'm sorry, my lords, in my record that
8 of 20.
578 of 21 at flag X.
Next, W8.
Yes, ma'am.
Just in this writ appeal, one IA has been filed 578 of 2021, and the prayer is for clarify the order dated 6/3/2020 and direct to delete the word generic from the operating portion of the order dated 6/3/20. 6/3/20. No?
6. Rochi may see the order dated 19/6/2024 passed in the writ. That will clarify everything.
What do you want, Mr. Behra?
I'm sorry, man. That IA I could not find in that bulky record. I will find it and survey copy if my learned senior agrees, my lords.
Clarification has been sought for by the Learned Council for the appellant.
No, for this by the state. There is a direction from this honorable court to the state to file a petition seeking clarification. Accordingly, it has been filed.
It is your application.
Yes, my lords.
On 19/6 we have passed an order.
1 and 2. And it was filed. You have not got a copy of that.
No, my lords, that entire
bulky.
bulky.
Not collecting in your pen drive.
My lords, today I'll collect it, my lords.
All right.
And let them serve a copy on me also.
It's true. I'll collect and survey
It
copy.
would not be better if we write that your petition is missing from your file.
No, my lords, that is what
we are not. We are just simply adjoining.
Yes.
On the request of the Land Council for the state, the matter be listed next week. Okay. Yeah.
Item 27.
My lord, 27 I am appearing for the petitioner. So here, my lord, for a direction for given an appointment on the compassionate ground, because the late father of the petitioner also put up 20-year service, and they have also, my lord, they harass a lot because he was also the class 1, grade 1 technician. Thereafter, he has been transferred and joined as the grade 3. Thereafter, due to his imbalance in mental condition, they turned into mad
and ultimately he was died in the corona that the year 2021. They have already considered for given an appointment on the compassionate ground, but they have not given the appointment as yet. Only it is taken off either by tomorrow or next week.
No, the last order,
sir,
that is passed on 29/8/24,
sir,
and the Miss Mano Ranjita Behera,
Manoranjita Behera, yes. Mother.
she appeared in person.
Sir.
I think now you have entered appearance.
No, yes. Since long I entered appearance, I argued the matter a lot.
No, the order reflects that the petition
No,
is appearing in person.
Resma Behera was appearing, her daughter.
Right. So she said that
Yes.
she has already engaged the council to argue the matter, and you are for the.
Well, I'm for the opposite party Nalco, and I'm praying for a password. If you'll understand, is praying for
He wants it tomorrow or day after. Tomorrow we can.
No.
We will see that. We'll see the our record, our diary. Then either it will be tomorrow or day after tomorrow.
Sir.
On the request of the land council for the petitioners, list this matter. Dekhini diary dekhini ye par do. That will be intimated to you.
Sir. Oblige, sir.
Yes.
Item 28.
May I please, madam? Last occasion, that is on 29th October, you will also have directly for CCR, and the noting is that the CCR is.
Please read the order dated 29/10/24. Have you got the copy of that order with you? Please come to the Wakam. But बाहर कर लें थोड़ा थुआ उची कि अपन माने व्यवहार करना दी
confused है जो
कौन confused होगा कौन अच्छी
20.
पढ़ो
The matter is taken through hybrid arrangement, video conference, counsel for the petitioner, file the date set and citations with the memo which are taken on record. During the course of argument, learned counsel for the petitioner placed paragraph number 13 of the counter affidavit in which the details of the service carrier, the proceedings instituted against the petitioner, and the average ratings in the CCR has been mentioned. And the first one states that during the initial 5 years of service, the petitioner had 4 average ratings in his CCR. In the rejoinder affidavit filed by the petitioner in paragraph number 24, it has been stated that it was not known to the petitioner whether during the initial 5 years of service he had 4 average ratings in his CCR, as it was never communicated to him. Now, counsel for the state placed the decisions of the Honorable Supreme Court in the case of State of Gujarat versus Sumedh Bhai M. Patel reported in 2001-3 Supreme Court cases 314, wherein while discussing the law relating to the compositor, it was held that the uncommented entries in the confidential record can also be taken into consideration for such purpose. Now, counsel for the state submitted that he is not having the CCR of the petitioner with him now. Let the registry place the CCR of the petitioner on the next day. List this matter on 5/11/2024. But after that, there are several dates are there, and CCR noting is that CCR is with the registry.
Yes.
CCR is
that we had asked very last. He was not knowing that the average is there or not. On scene, we can
please see. ठीक order follow. Lekhi order sheet में mention करिए. CCR is received and it is open
in sealed condition, which is opened in the court. And after perusal, restart.
The first one says that during the initial 5 years, the petitioner has 4 average rating of 90.
हाँ बोले मैं देखने को फाइल में मुझे पढ़े फोटो खींचे मारा वजह से चीज
So that is their average for at least 4 years in the 98, 99, 2001 and 2. And uh, this has been taken into account along with other things, of course. And that is why you are asked to retire at the age of 55 from the post of Judge Family Court Nabrangpur under Rule 44 of the Odisha Superior Judicial Service and Odisha Judicial Service Rules 1, so Annexure 1.
फाइल नहीं
So you are ready to argue the
Yes,
point?
yes, ma'am.
Yes.
My humble submission is that
Let us see that citation which the
yes,
State Council is placing reliance,
ma'am.
because your case is that the so far as that
After
average
ma'am,
marking is concerned, noting in the CCR,
ma'am.
that has not been average rating in the CCR, that has not been communicated to you. The State Council has placed reliance on that decision. It says that even if uncommunicated entries in the confidential record can also be taken into account for this purpose.
It is not decision.
In this respect, my humble submission is that the judgment of Umed Bhai Patel case is that has been delivered by the 2 judges bench of the Supreme Court, and I am citing the 3 judges bench of.
Let us see those citations.
Well, I have given you also can have a glance at my compilations. The 3 judges. I will show 3 judgments.
It was placed in record. This
yes,
compilation.
It has been placed on record.
Right.
What is that?
I am showing first Shamdev Singh judgment.
Just a minute. We want to see first that decision with the State Council placed reliance. That is Umed Bhai M. Patel.
I have also annexed in my.
You have given that.
Umed Bhai Patel at my page 51.
Just a minute.
And for distinguishing purpose, I have placed almost all the relevant judgments.
It is 51. Yes.
51.
Yes.
51.
No, 51 is Umed Bhai.
51 Umed Bhai.
Ah.
But this is the two judges bench of the lordship kind of.
All right. What has been held here? What has been held in
About the non-communication?
That if one of the grounds your lordship kind of test delivered 57.
57.
The same light also V double I. 57 11 the para 11 the V double I. If the officer was given a promotion despite adverse entries made in the confidential record, that is a fact in favor of the officer. This is my.
No. In the same para 11 C
other points are there.
6. No. 5.5. Even uncommunicated entries in the confidential record can also be taken into account. But these are all decisions that you are showing long back. Many new decisions have already come up in the matter.
This is the
with regard to the compulsory retirement, with regard to the average CCR, all new decisions have already come up. In 2024-20, where is those?
There may be different decisions.
No, not different decisions. Kindly come through that. These have been referred to in those decisions.
New thought has been given, so that is exactly point out. Are you aware about the latest position on this compulsory retirement as per the decision of the Honorable Supreme Court in 24?
Please go through.
But my purpose is that three.
No, your purpose.
Yes, purpose.
There may be distance. There may be.
Once you have not gone, please try to go through those decisions.
That may help you. We don't say that it's not. We don't know, but recent developments are there.
Once you are telling you are perhaps you are assuming that those decisions are against.
No, kindly come through that.
My purpose is that my juridical decision.
Please verify those decisions. 2024 Manupatra Mardiyantu
22, 23, 24, all these matters have come.
Are there. Please. So we can take it off if you want that. You
get ready with those. These are all old decisions.
We can take it on 2nd of December 24. Or let it be better if we come on a supplementary list on 3rd or 4th.
Yes.
May I pray for fresh admission?
Why?
রিচ তো করুছি বর্তমান 10টা 45 রে রিচ কলা আর কোন আপন এই যে 11টা 45
আজি রেসপেরিয়াল
yes see all right the Land Council for the petitioner took some time to go through some recent citations on the principle laid down by the Honorable Supreme Court on compulsory retirement. Matter be placed 3rd of December 2020. Yes. Acha, eita lekhi debe. It was opened and it was again
resealed and be returned to the registered registered administration.
And it will be placed on another time. All right. We have verified and return to it. All right.
Another thing, my purpose is that after promotion, what are the adverse remarks?
That is why we ask you to go through what is the consequence of a promotion. After a promotion, if a compulsory retirement is order of compulsory retirement is there, what is the consequence of it? Even after a promotion. That is why we are telling you. Go through.
Item 29.
Item 29, my lord. Item 29, madam, pray 1 week time for filing rejoinder, my lord.
Who is the opposite party? State.
State, man.
All right. Land Council for the petitioner submits that he has received the counter affidavit filed by opposite parties number 2 and 3 and intends to file rejoinder affidavit. And the matter may be taken up 2 weeks after. List this matter. Give it. Yes.
Item 30.
In 30, the Paraju have received a press some time to file counter.
Ready?
The Land and Council for the state submits that para-wise comment has already been received, and some time may be given to prepare the counter affidavit and serve it on the Land Council for the petitioner. The matter will be listed in the second week of January 2025. Counter affidavit be served on the Land Council for the petitioner. Within 2 weeks, they be within 2 weeks, and rejoinder, if any, be filed by the Land Council for the petitioner in the meantime. Yes.
Sometimes in December.
ନାଇଁ 2 ସପ୍ତାହ ତାଙ୍କୁ ଦିଆଗଲା, ଆପଣ ତାପରେ ପଢିବେ, ଛୁଟିରେ ବସିକିନି ପ୍ରିପେୟାର କରିବେ, ରିଜେଣ୍ଡର ଫାଇଲ କରିବେ, ଶୁଣାଣି ହବ ସେକେଣ୍ଡ ୱିକରେ second week of yes.
Item 51.
In this matter, writ petition challenging.
They have challenged the
Appellate court order.
the DRT, my lord. In this case, I am for the auction purchaser OP number 3, my lord. And the counter has not been filed, my lord. A short date may kindly granted.
My lord, only
7 days.
My lord, the DRT, I have filed challenging the auction. I have filed essay before the DRT. Learned DRT has condoned the delay by on the taking into account the principle of natural justice, that the property worth of more than 1 crore has been sold at rupees 11 lakhs. So, but that order was challenged before the appellate authority, and the appellate authority has dismissed the rejected the order of the learned PODRT, holding that the delay has not been properly explained. The fact of delay, my lord, on 2 grounds. One is due to the strike, my lord. At that point of time, 2018, there was a strike.
No, now if it has not been, then again matter has come back to.
No, it has not been, since the delay could not be condoned. So it has.
You have challenged.
Therefore,
Yes.
I am before it. I am out of my property, my lord.
All right.
7 days.
Let it be next week, sir.
Next week, my lord.
The Mr. S.K.Sahoo and Council appearing for the
Opposite party number 3, my lord.
Opposite party number 3.
3 auction purchase.
The auction purchaser.
My lord.
6 time till next week to file the counter affidavit. Let the copy of the counter affidavit be served on the Land Council for the petitioner. Matter be listed supplementary in ASU.
My lord, my lord.
Matter be listed on 4th of December 2024. Yes.
Obliged, my lord.
Item 32.
Item 32, my lord. My lords may kindly see the order dated 31/8/2024.
Yes, have you got the copy of that order?
My lord.
Please read it out.
My lord. This matter is taken up through hybrid arrangement, so and so. During course of argument, Mr. Mukherjee Larned, his senior advocate appearing for the petitioner, brings the notice of the court to Annexure 10, which is annexed to the additional affidavit filed by the petitioner, and submits that one Chittaranjan Mahapatra, who is similarly situated like that of the petitioner, has received full pensionary benefits. By order dated 28/2/2024, Learned Counsel for the State was asked to obtain instruction as to whether any employees in the judgeship of Baleshwar or any other judgeships who are similarly situated like that of the petitioner have been granted with the pensionary benefits or not. Even 2 days have passed thereafter. Learned Counsel for the State has not yet obtained instruction in this matter. However, Learned Counsel for the State submits that he may be given 2 weeks more time to obtain instruction as per the order dated source.
I pray now. The letter has issued on 13th/11. I pray is not received. I pray for next week. So that
you deposit 10,000 rupees in the High Court welfare fund.
Only for next week.
That is available not only to the petitioner side but also the state side. So after the last date, when last opportunity was granted,
yes.
Thereafter, if you are seeking, the order is dated 28/2/2024, and thereafter, how many time you have taken adjournment
Four
to just
days.
obtain instruction that whether similarly
Similar.
situated persons have got the relief or not. So if you are unable
I may be excused for that inconvenience that next week only, with 13th today I will be personal talk for to obtain that instruction. 13/11 notary is issued. I'll personally I will take care of that next week.
Land and Council for the state 6 for adjournment till next week to obtain instruction as per the order dated 28/2/2024. The Land and Council for the petitioner opposed to such adjournment as several adjournments have already been taken by the Land Council for the state in that respect. Be that as it may, place this matter on 4th of December 2024. It is made clear that no further adjournment shall be granted to the Land Council for the state. Yes.
Obvious.
Item 33.
Made. In the land house T, the entire land, 100% land was acquired for the purpose of NTPC Konya Mine.
What is your prayer in this retribution?
For rehabilitation appointment.
What orders were passed previously?
Madam.
Okay. So counter is
Counter.
there. Is complete. So reading complete. You are ready?
Claim against the NTPC.
No.
NTPC panel laws.
NTPC is there.
NTPC.
You are for NTPC?
Yes. State rule is limited.
Have you prepared any date chart or something like that? That what is your short point synopsis like? The final hearing, these things are minimum necessary. This date chart, your points, just we don't want that.
Next week. Next week.
The pleading is complete and the Land Council for the petitioner submits that he will file his synopsis and along with the points, grounds in challenging the impugned order next week, serving copy and the Land Council for the other side. Out of this matter, the Asu 4 तारीख दिन Asu. Now you want more time.
Lesser time. I can do it.
No. This week it is not possible. So we are bringing it in the supplementary.
8th, madam.
8th. Totally 4 तारीख दिन. 4 तारीख.
4th.
I also filed a resolution.
Mr. Tripathi, Land Council submit that he will also file the written note of submission for opposite party number. Opposite party 1 NTPC, no? Opposite party number 1. Yes.
Item 34.
Before my lord, I may pray before learned seniors.
Yes, madam.
The citations and other things are filed and record. I pray for next week only to go through that.
Pleading complete.
Pleading complete.
Written note I have filed, madam.
I pray for only next week.
I have filed written note of submission and a list of citations also. So
I have not gone through. No, I am not gone through. I pray for
Copy solve this.
copies.
Right. Asked for by the Land and Council for the state this matter. एक डेट देखी तो बेसी गुड़ा का मैटर दे दिया 11 सप्ताह रे फाइनल तब तक गोटा पर सप्ताह नहीं आसे ऊपर सप्लीमेंटरी है ना देखी करियो.
Well, I'm also filing another list of citations subsequently found out my last.
आगे फाइल करके दे दो.
हां दे दो. आगे लोटे फाइल करजी ना subsequently I will file.
Land Council for the petitioner files the citations which have taken.
Copy solved, my lord.
Copy solved on the Land Council for the. Yes.
You're gonna 4th, my lord.
It would be either on 4th or 5th, or you'll see the diary. Otherwise, it would be on the week commencing from 9th.
9th.
Just
9th, my lord.
You can
9th.
get it.
Item 35.
35 minutes sent by the petitioner. On behalf of operative bank, Guru the Kora, accommodation, sir. Kali Gasu matter.
Any objection
No,
to list this matter tomorrow as prayed for by the land council for the opposite party? Yes.
Item 36.
Yes, Mr. Sharma.
36, last occasion, state took time on the plea that registry is going to file a counter.
No, counter has already been filed, perhaps. Filed.
No, counter filed by the state. Adjournment was sought for the purpose of filing by the registry.
Or registry.
Yes. Registry had not
filed. Sir.
So you have filed your counter, but you have to obtain instruction whether the registry want to file the counter affidavit or not.
Today.
So that is the order passed.
That I verified that.
No, Mr. Prabhu's on last occasion said registry is going to file the counter.
Okay, so
the registry has prepared it. What I converse.
Already prepared.
It is in the process of filing after waiting.
All right. The Learning Council for the state submits that the counter affidavit on behalf of the opposite party number 2 is under preparation, and the matter may be taken off. It would take 1 week time. We are listing it on 9th December. Matter be listed in the week a week after, so that the copy of the counter affidavit of the opposite party number 2 shall be served on the Learning Council for the petitioner. List this matter the week commencing from 9th December 2024. Or you do it, you doing it in the supplementary on 10th of December 2020. Yes. Mr. Bigyan Kumar Sharma, Land Council for the petitioner is present. Yes.
Item 37.
Lordship, item 37, I on behalf of Mr. Subrat Misra, he is suffering from fever. So may kindly taken.
Who is appearing? Who is appearing for the petitioner? Mr. Nilamadha Praharaj. What do you want? You want adjournment?
Yes.
Now appears for the petitioner, Learned Council. A mention is made on behalf of Mr. Subrat Misra for adjournment on his health ground. Is this matter next week? Yes.
Who bless?
Item 38.
In this case, I am for respondent. I seek for time and next week I tell.
You are for the petitioner. The Learned Council for the appellant is present. Learned Council for the respondent seeks for an adjournment till next week. Let this
Ranges.
You are for the bank.
I am for the bank. I am citing 2 judgments.
In this case, let me, before I begin, Lord, I am guilty of not filing the note or jet check. The pleadings are complete. Pleadings are complete. I have filed
Take up tomorrow, Mr. Mahanti, if you want. For this, you want to file the synopsis or the
written note. I have prepared it, but
it will be convenient if you take up tomorrow or day after tomorrow, whatever.
My difficulty is I will be absent for the week. Your Lordship can, till 15th, Lord, I will be, there is an occasion in the family, Your Lordship. So after 15th, if Your Lordship kindly accommodates me.
Is there any interim order?
Yes, my lord. There is an interim order because my lord OA is pending before the DRT. And here is the read petition. Simultaneously, both are running. So very the public money is more than 4 crores are there.
Anyway, Lord, I pray.
I think the read petition is not maintainable here. That is why I am citing 2 judgments of Honorable Supreme Court of India. Your Lordship kindly have a glance.
Well,
because this is a read petition and the OA is pending. They are not appearing before the Honorable DRT because
OA has been filed by whom?
Us, my lord. Notice has been that OA is they are not appear. That is why the Honorable DRT
Why have you filed the OA?
For recovering the dues, my lord.
Okay.
But this is not related to recovery of dues. This is related to the checking of an arrangement made by this Honorable Court. Pursuant to Your Lordship's order was implemented and decision was taken
with the bank. In the midst of the continuance of that implementation of the decision, this matter has come.
No, property
Counter.
involved is the same.
Same,
Yes,
same,
property
Miller.
is-
Absolutely. EMTD also made
Under
everything.
the Annexure 3, they say that we'll take over possession because not just may I just refresh your lordship, not this. Not the unit was taken over.
Yes.
Then the matter came to your lordship's court. Lord, your lordship made an arrangement that your lordship may kindly see that order. I've quoted that. Lord, page 3 of the writ petition. Lordship kindly see. Paragraph 3. In compliance to the order dated 6/2/23, the court Patra senior manager appears in person and admits that the petitioner has deposited rupees 50 lakhs as directed by this court in compliance to clause 2 and 3 of the settlement dated 13/12/21, and the same will be adjusted. After adjustment, now the petitioner has to pay 18.67 lakhs so that the bank account of the petitioner will be regularized because this amount is remaining overdue against the petitioner. Thereafter, if any requirement is there, the bank will intimate the same to the petitioner so that the petitioner can comply the same and run his account smoothly by paying EMIs as fixed by this bank. This was the counsel. As the land counsel for the petitioner states, the petitioner will comply by paying 18.67 lakhs by the end of this month so that the loan account which is lying with the opposition will be regularized. In the event the bank intimates for production of certain document, the same shall be produced in the month of March so that the petitioner will be allowed to pay the installments which has been fixed earlier for smooth running of the bank. With the above observations. Now this order was passed. This order was complied in letter and spirit.
You deposited
that amount, deposited the documents. Then a conscious decision was taken by the bank. That your lordship may kindly see. In pursuance of your lordship's order, directive, a conscious decision was taken at Annexure 3. 1. They have given the history, what I read out. Thereafter, the page 12 is the outcome of that meeting. Review meeting of the unit will be held last week of every month. It was decided that the unit will be made workable. I'll be permitted to proceed with the unit, and this arrangement will continue. Review meeting of the unit will be held in last week of every month with 7 days prior notice by the branch. Stock test statement will be submitted every month at a branch without fail. This is important. The sale proceeds of the existing proposed stocks will be exclusively utilized for payment of bank EMI interest at 50-50 ratio will be credited to loan account on weekly basis, and 50% will be adjusted by the firm as working capital for running of the factory. The rest of the the cardinal decision was that it will be made workable. I'll run the factory, 50-50 will be adjusted. That was subsequently changed under Annexure 2 to 80-20. 80-20. Now, there is no allegation that there is a default of on our part or anybody's part so far as this arrangement is concerned pursuant to your lordship's order. There is no complaint. But suddenly they say at page 17, Annexure 3, during the third paragraph, your lordship, during the review, it was observed that you could not achieve the projected sales figures as an ETE, as you have achieved approximately 30 lakhs as an. In such case, you will not be able to revive the viability of the unit as such the sales settle sale rate. As such, further, you have not infused any further capital, neither has proposal sale of state stock. In this scenario, land holding support cannot be further provided. As such, review meeting in Assur decided to stop the sale stocks to go back on that decision. But the only question when the only question I asked myself before filing this, if the arrangement is continuing, if there is no default and the monetary part is secured, whether my unit is running or not is not a pertinent question to be decided. Suppose my unit is not running, but I comply with the order.
But comply means the amount which the bank must be receiving must have been reduced in that way.
To a great extent. 80-20. No, that's that for looking and what was the if in page 16 Page 16.
16, yes.
Page 16. Rather, it starts from page 15. 8, the second review meeting. On achieving such sale figure, a 2080 cutback may be allowed by competent authority upon reviewing the account. If the account be remain regular thereafter and continue with 2080 cutback for 6 months, where satisfaction of the bank dues are covered by 20% of cutback, then cash credit account may be renewed after due review. Now, this is the question which your lordship is asking. If borrower fails to satisfy the monthly dues 2080 cutback in any of the month during the said 6 months period, restoration of 50/50 cutback will be invoked from succeeding month and surface action. So what will happen? What your lordship is posing, that suppose there is, your lordship is right. When what was he getting, the bank getting, that will come down. In that case, they decided that it will go back to 50/50. Not to stop at closing. Close the unit, because closing the unit will be beneficial to no one. Neither I can give nor. That is the question. Suppose the sale falls, but the monetary part is secure. EMI is there. Your lordship may take it from me. Till today, there is not a single default, and there is no outstanding. So the question is, if annexure 1 fails, then as per annexure 2, you again go back to annexure 1, 50/50 to recover the dues. But closing the factory will benefit no one.
So what is your answer to that?
My lord, the factory is now running. He's only depositing the installment amount, and entire sale process they have to siphon any other account. They are not maintaining the account regularly, and their income tax and their stock limits they are not disclosing us, and their GST that is cancelled by the department. And another thing, they are not cooperating.
That is your counter.
Yes, my lord.
No,
I have already stated in all those things. Your lordship kindly have a glance to my counter affidavit and as well as the reply affidavit to the rejoinder. I will disclose everything, my lord.
That is why you have now you have gone for
recovering the dues and filing the original application before the DRT.
And he has already entered appearance.
No, my lord. They are not appeared. No, my lord. The matter is for ex parte hearing. Last time. They have not appeared. They have received the notice, everything.
There cannot be a dispute.
When I show the notice to the Honorable PO, immediately
when a senior advocate makes a submission, we expect that.
My learned friend is appearing.
I'm 100% right.
So
because
he has stated that he has already entered appearance.
No, my lord, I'm personally handling that matter. No associates are there. Last occasion, I personally pray before the bench to put up this matter on ex parte hearing, and they agree. And he also directed me to produce the original document.
What is the date?
Next date.
Yeah. For ex parte hearing is best.
Oh, the minute. They will slip
whether any steps have been taken.
Yes, appearance has been made, but the copy of the paper book has not been supplied to us. That is why it is being urged.
No, my lord. So totally wrong, my lord.
Totally
my submission may be recorded.
There cannot be contradictory statements are being made by the party. We are doing one thing. We are keeping this matter to tomorrow. Yes. Please
file affidavit.
File affidavit. You said that it is on the ex parte hearing. He said that he has already entered appearance.
Yes, my lord. And, my lord, may I produce the order sheet? DAT order sheet?
If you can
that will be fine, my lord. Because
once he has entered appearance, that must have been noting that
100%, 100%.
And my associate, Mr. Gui, is appearing there. In that case.
No.
I don't have any
That's a long
doubt about my learned friend's submission, because he is conducting the case there. I don't have any doubt. But equally, my learned friend says that he has already
simultaneously, my lord. How can
just bringing this matter tomorrow? Please apprise us the position in the
My lord, गोटे पर्सनल डिफिकल्टीज रही मु affidavit काली की फाइल करि परिबेने एथिपाई से ब्रांच मैनेजर नाहंती काना
You file this certified copy of the orders.
सर्टिफिकेट कॉपी मिली परिबनी गोटे दिन रे डीआरटी रु काना पीओ नाहंती जो नेट रे जोटा अछि आई कैन फाइल आल्सो सब दिन सता अछि नेट रे अवेलेबल अछि
out of this matter as prayed for by the land council for
मु
both
काली
the
सेटा
parties.
फाइल कर देबे ऑर्डर
this matter on tomorrow is 26th or 27th near so 27th of
I was praying
deeply obliged
I'll be absent for the your lordship kindly afford it.
no you just want to see that
Yes, status.
thereafter we'll ask
my learned friend will be there
27th रे खाली आनुछु position देखिया ପାଇଁ we'll see that
my lord pleadings are already complete counter legender yes ma'am
27 my request may kindly be noted because I'll be absent my learned friend will be there
27th
because the public money are there my lord
27th of November
obliged
here
Item 40.
Item 40 relating to notice, your lordship, में noting is there in the list. Lordship may see that fifth line of the noting, this fresh notice issued to OP 3, 4, 5, 6, 7, 15 and 24. AD from 6 and 7 returned after valid service from 6 and 7.
so
that is sufficient. Then notice
just
returned from 4 and
minute.
my lord.
The registry has reported that so far as that press notice has already been issued to opposite party number 3, 4, 5, 6, 7, 15 and 26 and AD from 6 and 7 returned after valid service. So this is held sufficient. A notice on this 6 and 7 held sufficient.
Then notice returned from OP 4 and 5 with postal report refused.
Notice on OP number 4 and 4, 5 returned with postal limit refused. It is also sufficient.
Then postal tracking report flag Q against OP 3,
15 and 24.
15 and 24 shows item delivered.
3 and 4, 3, 15 and 11 postal tracking report.
Say 15 and 24.
Then postal tracking report are flag R.
So it is also held sufficient.
Postal OP 12, 18, 22, 27 shows delivered.
Postal tracking so on so report. 8 of more than 5 of the space sufficient held sufficient.
Then 27 delivered. High Court Judiciary section. As against OP 19 shows under inquiry at office of SPO. I will take fresh notice to 19th inquiry.
Party number 19 it is reflected as so and so. Steps for fresh notice shall be taken. Opposite party number 19 ପାଇଁ
Then against OP 14 at flag P shows notice served on Ranjan Kumar Das. That Ranjan tar ghare somebody is received on behalf of
OP 14 notice sufficient.
Postal tracking report against OP 16 flag shows notice served on one S.K.Sahoo Hon'Ble. Postal tracking report against OP 21 shows notice served on Vijay Kumar Parida on 3/4.
Notice sufficient.
Postal tracking report against OP 31 at flag P shows notice served on Gita Kumar Behra on 3/4.
Yes.
Postal tracking against OP 32 flag P shows notice served on Vikas Kumar Naik on 1/4. Notice returned from OP 9 sent. So I will take fresh step on OP 9.
Opposite party number 9 time fresh steps shall be taken.
Here the postal remote address is left. That unutilized copy here be utilized.
Unutilized copy be utilized. No number fine.
But in the correct and present address you have to take.
Yes,
because once address is left means.
So only 9 and 19 is
step with correct address.
9 and 19 I will take first step. In the next case, your lordship may see. 19 ପାଇଁ ଦିଟା
fresh step taken. ଆଉ ପ୍ରେସ୍ କେପ୍ର ଏଇଟା ଲାଷ୍ଟରେ ଲେଖା ହବ unutilized copy utilized. Yes, next କଣ
Next, it is sufficient with counter. Notice was served again. Press notice issued to OP 5 and 7.
item delivered আছে
Item delivered 5 and 7.
notice sufficient है ना.
चलो इसमें fixed date.
Clear करना है तो लेके जाओ non clear problem है ना.
My lord, we are for the railway.
the
First case Mr. D.K. Sahu, second case Mr. D.K. Padi.
Mr. D.K. Padi, Land Council. First की ଅଛନ୍ତି କାହା ସାଙ୍ଗରେ?
Mr. D.K. Sahu.
Mr. D.K.
Dilip Kumar Sahu.
Dilip Kumar Sahu, CGC.
Second case Mr. B.K. Padi.
Second row Mr. Padi. है ना? Okay. So then D.K. Padi, Land Central Government Council, along with Mr. Yes. ତାକୁ detail ଦେଇଦେବେ. Fresh stiff notice you take
within 1 week.
Within 1 week. ହେଲା ତାପରେ ଏଇଟାକୁ ରଖିଦେବେ ତାର ଜେନେରାଲି 4 weeks ଦିଆ ହଉଛି ସେ ଆସିବ. Yes. We are just coming within 1.
Item 31.
May I please, Your Lord? With your Lordship's kind permission, I'm filing a note and the citation. Those. May I, with your Lordship's permission, place the written.
So virtually the matter was remanded to the DRT. That is the order of the DRAT in Miss Appeal number 32 of 2023.
No,
Right.
but the order has been set aside, Your Lordship.
The in the operative portion, it has been mentioned in page number 24, internal page is 5, that imprisoned order is set aside. Parties would be at liberty to raise their plea before the London DRT in accordance with.
That is with regard to the merit of the case. So far, the interim order is passed by the land DRT is concerned, that has been set aside by the DRT. I will demonstrate from record how it is erroneous.
What interim order was passed?
The interim order was passed. Your Lordship will kindly see. Your Lordship will kindly turn to page 26. 26. The only residential house of the petitioner was put to auction. The petitioner has a right to challenge the auction process and the consequential action by the collector that was challenged in the appeal that was filed for the land DRT. Now, land DRT.
You filed.
Yes.
Okay.
Land DRT asked us to deposit the entire amount. That was, the Lanet Appellate Court, I will demonstrate, has misconstrued as if we are claiming for a redemption. We never claimed for redemption. I will show to your Lordship from my application for the DRT. Now, under that misconstruction, this order has been set aside. This was given as a security for the purpose of interim order, and the land DRT is well within its jurisdiction to pass interim order. That also I will assist your Lordship. Now, that has been set aside by relying upon a decision which is not applicable to the fact situation of the present case.
Now, what amount the DRT has asked you to deposit?
That 26,60,000 which we have deposited.
So, how much you are ready to deposit?
Now, we have deposited the entire auction amount, Your Lordship.
Then you can go on for that final hearing. What is there?
This order has been vacated, but I am in possession. Now, the possession will be taken over. That is what was protected, my lord.
No, but till the final disposal, both of you cooperate. That can be concluded with specific.
That we are ready, my lord. We are ready, my lord.
In view of the judgment of the apex court,
that I will assist.
What the London DRAT has reflected in their order.
No, he's still in possession, he says.
But yes, by that time the auction has already been held. Self certificate has been taken by the time filing of the.
You place all the matter before.
But because after 2 years they have filed the case.
We are not saying anything. We are just saying that the OA is sub judice and the parties agreed to cooperate with the London DRT to for expeditious hearing, so that the matter can be disposed of, preferably within this December 2020.
I have objection. I am appearing on behalf of Mr. Bose because he is ill.
Yes.
He is hospitalized. For that reason, I am appearing on behalf of Bose, my lord. I have objection to that effect because after issuance of self certificate, only possession, collector has already passed the order. Only possession has not been handed over. At that point of time, filed the essay and interim order has been passed. Interim order has been passed on deposit of the entire auction amount, and in absence of the auction purchaser. For that reason, auction purchaser has challenged the same.
Because you see, this writ petition is filed against that order.
DRT order.
DRT order. But the main application is yet
Still
sub
with
judice.
DRT.
So
Yes, madam.
now the main application, all those contentions which you are raising, that can be taken care of if that is disposed of within a short time. So you can show that
Your
decision.
lordship has ample
Bhasna
power to
case,
pass this
other
order. I am
case,
not
so you can
saying,
show
but
that.
in
that
view of the judgment of the FX court, after self certificate is issued,
but since the main application, if that order would have been passed, matter is different. Main application is pending. Interim application, this order. Why will go into the merits at this stage when the merit has
not on merit. I am not
saying that all those things. Why?
Because already self certificate has been issued. We are in the stage of possession.
No,
And the auction purchase
had the parties not before the DRT and they would have come here. Probably we could have said this.
Before issuance of notice to the auction purchaser, this interim order has been passed. For that reason, the auction purchaser has preferred the appeal.
And the amount is already has been deposited.
We are not concerned about, because after sale there is no power on the part of the bank to receive the amount also.
My lordship, I am for the auction purchaser. My lordship, if I may can humbly submit, my lordship. My lordship, the essay has been filed.
What is the date fixed for that way?
My lordship, 2 December 2024.
All of you appear on that day, second.
My lordship, we are appearing there, but I may kindly be heard, my lordship. I am the appellant before the DRAT, my lordship. I may kindly be heard.
Mr. Counsel, that is an interim application.
Yes, my lordship. Just my lordship. Let me place two facts before my lordship. Thereafter, my lordship may tell.
No, what kind of order you expect from this court?
No, my lordship. I'm just placing.
Can we take it on merit?
My lordship, two
You are already before the DRT.
No, I'm not stating anything on merits, my lordship. I'm just placing the fact, my lordship. Just two facts.
What will happen to it?
My lordship, the auction was on 23rd of February 2022.
13.8 is over.
My lordship, last year I was before this Honorable High Court.
13.8 is already over.
My lordship, High Court has passed the order to deliver me the physical possession. Thereafter, they approached the DRT.
Why don't you take it before that?
My lordship, they filed the essay and took the interim order without my presence. After High Court passed the order that the physical possession be delivered to me within a period of 15 days. It was not delivered. I filed the contempt petition. Thereafter, my lordship, the collector has passed the order wherein it is very clearly stated that even though section 14 is not adjudicatory.
This writ petition has been filed by the petitioner Banshidhar Behera.
Interim may kindly not be vacated. Interim may be vacated.
Order dated 12/4/2024, passed in misappeal number 32 of 2023 by DRAT Kolkata, and to confirm the interim order dated 26/9/2023 by the DRT Cutter in essay number 161 of 2023. As it appears on the learning DRT on 26/9/2023 has passed the following order. The operative portion like the considering so and so to purchaser present. When this order was challenged before the learning DRT by the auction purchaser, who is the opposite party number 4 in this writ petition, the Learning DRT by order dated 12/4/2024 allowed the appeal and set aside the order dated so and so of the DRT passed in so and so, and directed the parties to raise their plea before the Learning DRT in accordance with law. The Learning Council for the parties submits that the essay is pending for hearing on 2nd of December 2024, and since all the parties have already entered appearance and the matter is to be adjudicated, let the DRT take a decision on the matter expeditiously, preferably within 2 weeks from the date that is fixed for for hearing, and pronounce the final verdict. And the Learning Council for all the parties submits that the parties will appear to their respective council on 2nd of December 2024, and they will not seek for any adjournment. Accordingly, the writ petition is disposed.
The operation of the order was stayed by the Honorable Court on 22/4/2024.
The
Status quo between the parties be maintained, but the operation of the order was
the
stayed.
order passed by this court in 23/4/2024 is extended till 2nd of
Till disposal of the case, because your lordship
No.
is
In fact,
carrying-
that was a
No,
there was
no,
a caveat in that.
No.
Caveat.
They were in caveat, they have been heard, and the order has been passed by the
No, no, my lordship, I was not heard, my lordship.
Yes, next.
Until disposal no hole, they will again dispose, my lord.
2nd December.
Your lordship may permit me to move there for further extension, my lord.
The petitioner is at liberty to move for further extension till the disposal of the original application.
Deeply grateful, my lord.
Item 42.
May I please?
EWC received a praise some other day for filing of counter for OP 1 to 6 states. Private opposite parties have filed their counter.
Which is this application for intervention?
My
Who
lord.
was filed?
My lord, I have challenged the order under Annexure 1, my lord, where my application under Order 1, Rule 10 for
Your
intervention has been
application,
rejected.
any order has been passed or not?
Against rejection of intervention, this writ petition has
Yes,
been
ma'am.
filed. Rejection of
My
intervention
application
by
has
the
been
land
rejected.
acquisition officer.
There is an application for intervention, IN number 959757.
Minor.
We just want to know that whether any order has been passed,
No.
that has been filed by who has filed that intervention? By one Santosh Kumar Behera.
Yes, yes. I have filed that picture.
You have filed.
Yes.
So any order has been passed?
No, my
No, your lordship.
So have you filed your objection to this?
I have not filed with the party who has filed the application. I have not filed any objection, lord.
Have you received the copy of the
Yes,
internal
lordship.
application? So the state council. So
We'll file objection to that.
And I will also file the
The intercede dispute between the
just a
opposite
minute.
party.
IN number 9757 of 2024. This is an application for intervention filed by one Santosh Kumar Behera. Land and counsel for the petitioner. So also the land and counsel for the state submitted that they have received the copy of the interim application and they intend to file objection
intervention application
to the intervention application.
Yes, sir.
Put up this matter. Gote saptah par lag
I have filed an application is pending for the stay of the further proceeding, lordship.
Just a minute. Put up this matter on 9th December 2024. Objection, if any, to the interim application be filed in the meantime. So, what do you want?
Let us stay for the proceeding of the LA, lordship.
Stay for the
Now they are not giving any date for adjournment. My application is pending. That is IN number 5553, lordship.
No, LA is sub judice.
Yes, lordship. Though the
So
parties are appearing here,
Huh?
further proceeding may be stayed, lordship.
Why further proceeding will be stayed? If all of you are appearing there and the,
Lord, my application for intervention has been rejected. So I am not contesting there.
over there you are not.
My lord.
The suit was filed. The suit is pending. His claim is that suit is pending, but no final adjudication has been made.
So
But
in the event the amount is determined,
determined
will be
in
affected.
favor of the legal heirs of the
I am
tenant.
the co-sharer.
Yes.
My,
By any means you will be getting. If
No,
you
my-
if you
the-
substantiate your status
my
to be one of
prayer
the
is, my
co-sharers,
lord, my
you have to-
averment is in the ROR, my lord, in the settlement operation, the present opposite parties they
No,
have
you sought
managed
for
to
your
enter their
intervention. You sought for your intervention directly before the LA, or
Yes,
you
sir,
got
yes.
your case referred to the
No, my lord,
authority.
in the IA,
That is why.
LA, lords.
So you have to get your name, get your case referred to the authority without directly intervening there.
Before the land
Because
acquisition.
unless it is referred,
My lord, I have not been My application for intervention has been rejected.
Obviously.
How can I submit the documents without any?
Before the land acquisition officer.
Before
That is the proceeding.
that's the procedure.
Procedural. A party who is not there, he cannot directly appear there. Your case has to be referred to the.
In 76, the order passed that
You
is
can't
rejecting
go with
apportionment
part
of
1 rule
share.
10. No.
My lord, I file an application before the authority.
Which authority?
That is opposite party number 3, your lordship.
Opposite party number 3.
Opposite party number 5, the special land acquisition officer.
You see this.
Sorry, your lordship. Without disposing of my application, the opposite party number 5 referred the.
There are decision of the Honorable Supreme Court and this court also that he has no power to entertain that application. I think
yes.
That's why, my lord, the matter has been referred to the central division.
So now,
my lord, the opposite party number 5, the special land acquisition officer referred my application without any adjudication to the opposite party number 4, the land acquisition officer, central division, Cuttack, your lordship. There I filed the application for intervention, and my application has, without any consideration, that has been rejected, your lordship. And on the ground, my lord, your lordship,
Opposite party number 4.
Yes, lordship.
He is not the authority. He is not the authority.
Because the matter has been referred to.
Might be, but he is not the authority to refer the matter. See, the provision is there. It's a clear provision.
Who is to refer?
Who is to refer?
Collector.
So
that is
5 has referred, your lordship. OP number 5.
No, he has no authority. He has no authority.
Mr. Counsel, jaha pakir nahi ta pakir kon koi dele se refer kar do ya apon case tabu. The appropriate authority, he has to refer the matter. And obviously, the persons who are not party, the other person, you cannot be impleaded as party there.
Yes,
he has got no power. That is the decision of
the present intervention application who has filed the intervention application, my lord, he is not the party before the LA.
That you have to go through that out.
Under 64, that collector will.
You are now given a opportunity to file objection to his interim application.
Yes.
Yes, no.
That we have not finalized. You can say same thing that he is not a party there. He cannot file and got intervened here. So same thing also applies to you. If you want that you are a party who has got the right to claim, then you are to also approach the authority to make a prayer that the case may be referred to the appropriate authority for adjudication along with LA number so and so which is pending. So your case can. He has got no power. The in the LA case, you cannot directly. That is the decision of the Supreme Court. So,
my lord, he has adjudicated the matter and rejected my application.
These parties, the opposite party, are to get it, and if they, what would be their share? Only new party cannot be added by that. So that is the.
Matter be referred by collector for determination of the authority as the case may be.
For the rejection order, you lordship may see at page 15, my lord.
Yes.
Page 15, my lord. The rejection order, the intervention application has been rejected.
By whom?
By UP number 5, my lord. 4, my lord. UP number 4.
UP number 4 is what? No.
Land acquisition and rehabilitation.
64 of.
But he has adjudicated the matter and rejected my application without authority.
No, your submission before that authority is wrong. It should have gone in 64. It is the collector who is to refer the matter for all purposes, whether his objection to be to the measurement of the land, the amount of the compensation, the person to whom it is payable, the rights of rehabilitation and resettlement, apportionment of share, everything he is to do it. It is only after the matter is referred by collector under section 64. So the matter has to go to the collector.
My lord, I filed the application before the collector.
Where is that?
No, where is that?
Fine. Where is the copy? Where is the order?
That is the crux of the matter.
No, that not included.
That has to be.
You have directly approached the authority, not the collector.
Or even OP part number 4. He is not the authority.
I have approached OP number 5.
Where is that? Now he is not the authority.
He is not the authority. The authority is the collector as per section 64. He has to refer the matter. And you have not approached the authority. You have directly filed the application for intervention before the LAR authority.
Instead of OP3, you proceeded to OP4.
And he has got no power under Order 1
Yes.
Rule 10 CPC. That is the decision. We are since the beginning we are telling you that that is the decision.
If you would have filed a petition before the learned collector,
Right,
so that if not consider or referred without intimating about his
Because that
reference,
is
then
my
you would have
appointment
got a
also.
rider to claim.
Page 5, para 3, last line, my lord. Or the OP number 3 and 5 without adjudicating matter. I have filed the application.
Then
My lord, I will obtain the instruction regarding that, my lord, of the filing of the application.
The decision of the Honorable Supreme Court, which clearly says, and our court also says that the authority, that LAR authority has no power to impede any party directly under Order 1 Rule 10 CPC. That is the decision.
Next, your lord.
এটা কেব্বে রখিলে সে যে খেয়াল রখি যান লাস্টে
Next, your lord.
The Land Council for the Swansea also wants to obtain inspection as to whether study the case law further, whether the opposite party number LAR
Four.
opposite party number 4 has the authority to entertain an application under Order 1 Rule 10 of CPC or not.
Next week, my lord.
It will come on 9th of December 2024. Yes, next.
Obliged.
Item 43.
Ram Kumar Naik, not there. Next.
Item 44.
Item 44, your lordship. On behalf of Mr. Rautre, counter has not been filed, your lordship.
Counter has been filed.
Not been filed. It is for the petitioner.
You are for the petitioner. Mr. Padi. Mr. Padi.
CGC accepts notice. Mr. Padi, you are able to hear us?
Yes, muted. 8.24.
Mute.
সুবিধা হবে না
He is only to find it.
No.
Only Union of India.
Only Union of India.
So rest are railway officers.
That is.
Unmute.
Unmute yourself.
11024 of this particular read. 2091.
Counter.
Mr. Pari, we are in item number 44, WPC number 16011 of 24. And you have not filed the counter affidavit.
Yes, sir. My lord, will put on the. My lord, this in this case, we'll have to file the counter affidavit. Let me give more time.
None has entered appearance in this case from the side of Union of India.
It is there is a period number next date is 10/9/2024.
They filed in additional repeat that was also sent to the department.
39/24. We have passed a detailed order on 39/24. And the Central Government Council accepts notice on behalf of all the parties. Extra copies of writ petition be served and counter if any be filed in the meantime.
Yes.
So that is exactly why it has come. Mr. Padi,
Yes, ma'am.
you want some further time?
Yes, for 2 weeks time maybe.
Okay. The Mr. Padi Land Council. Anybody's name is to be
S.S. Kashyap. S.S. Kashyap.
S.K.Sahoo Hon'Ble Central Government Advocate. Seeks some further time for filing the counter affidavit. List this matter. Give a date of. Yes.
Item 45.
The 45 may can
The government is supposed to file a counter, ma'am.
Lordship may can have glance to order dated 1/10/24. Oh, sorry. So that is single bench. That's and I may exclude. That is previous order.
Previous
We have it has
That
come for the first
PWC,
time.
we have received the PWC.
What is the online council and so on. So issue notice, extra copies. He is a valid lease holder in respect of Dharmasala Bhavan, executed on 10th November 21 for a period of 10 years. He is regularly paying the annual rent. The last annual rent received for the year 2024 is produced by Annexure 6. It is submitted on behalf of the petitioner that he, after getting lease of Dharmasala Bhavan, has opened a food court inside the campus, and now the authority are proceeding to evict him from the said court. So interim order is there.
Yes.
You have not filed the
No,
counter.
PWC have received.
All right. The Land and Council for the state submits that Parawai's comment has already been received, and some more time may be required to finalize the counter affidavit and file it and serving a copy on the Land Council for the state court of this matter. Give it in a month of January, and interim order dated so on, so is extended till next day. Yes.
Okay.
It's hard, Mr. Nilan Kanungo, Land Council for the senior advocate for the petitioner. Yes.
Obliged.
Item 46.
46, my lord. As per my lordship order, my lordship, last occasion, my lordship directed to take instruction whether the
Just a minute.
existing vacancy is there.
Land Council for the state 6 1 week time to
For non-joining the
instruction
candidate.
as per order dated 1/8/24. 1/8/24 order for it.
Oh,
I ordered 1/8/2024.
yes, sir.
more
If
time
any
will be
vacancy is there or it has merged.
Yes, my lord. I'm sending the letter, my lord. I pray some time to find the instruction. They are not supply the instruction. First week of December, my lord. ପଠେଇ ଦେଇଛନ୍ତି ଆସିଲେ November.
The order was passed on 1/8/24.
My lord, my lord.
And it again was restated on 12/11/24 in time. So now we are on 25th.
Next week,
Next week. All right. ଏତିକି ଇନଷ୍ଟ୍ରକ୍ସନ ଆପଣଙ୍କର ମାନେ ଅର୍ଡରଟା ଯେ ଦେଖିବେ to obtain instruction with respect to the vacancy position, the status of the candidate Ananya Mishra, whose names find place in serial number 3 of the select list, and whether the vacancy caused due to non-joining of the said candidate has been merged in the next advertisement. This much of the put of this matter in the week commencing from 2nd December 2020. Yes.
Item 47.
Notice issued to OP number 3, my lord. Sufficient address has been session, ma'am.
You are to file a correct address, press requisites, address left and unutilized copy will be utilized.
No, my lord, address if notice issued in a proper address, that may be sufficient. This principle of Supreme Court also held by this honorable court also. My lord, I'm sorry. If notice is issued intentionally avoiding,
Where is the endorsement?
I am a lonely.
Where is the endorsement?
My
Postal endorsement.
postal endorsement, my lord.
Address left.
Left out.
My lord, this is just.
You go for order 5 rule 20 then.
Supreme Court order is there, my lord. In view of AN 89, Supreme Court I am handing.
What for?
I am handing.
No, regarding what?
If proper address in notice has been
No,
served,
no.
that will deem sufficient, my lord.
All right. In that case, you go for order 5 rule 20, paper publication.
My lord, this is the.
We are aware of that. We are aware of that.
This is a coordinate bench also held on Supreme Court order also. I am bringing up
You file it.
citation, my lord.
You
If
file it.
notice is issued in a proper address, that will deem to be
Proper in this sense, how could you know that it is proper?
Address has been given in my brother. OP3 is my brother, guarantor. He is filed lead person, and in proper address, I am the brother of OP3. OP3 is my brother.
What is the status of the case? 13.4 is already there.
No. In this case, what happened?
Property mortgage.
He is the loanee, and the brother is a guarantor.
Right.
And the property is a joint family property. It has been mortgaged. Now after sale, the amount has come to the bank. It has been appropriated, and thereafter possession has been handed over. At that point of time, he is coming to take back the rest of the amount, 50% of the rest of the amount. His brother has filed a suit claiming that house also. So if this suit is not withdrawn, we are not in a position to hand over this
suit is now pending.
Yes.
No, this is not correct, yes. I am not my last order, my lord. This is pursuant to last order. I have enclosed that suit where I am not party, my lord. My lord, specific order, my lord.
Against file last
order. Are you aware about that your brother has filed a suit?
My lord, unless that document.
ଆପଣଙ୍କର ଭାଇ ଯୋଉ ସୁଟ୍ ଫାଇଲ କରିଛି ତା ଦେହରେ ଆପଣ ପକ୍ଷ ଥିବେ ନମ୍ବର କେତେ
that document pursuant to previous direction I have annexed that document.
Baba suit number କେତେ କୋଉ କୋର୍ଟ ରେ ପେଣ୍ଡିଂ ଅଛି କୁହନ୍ତୁ
CS 390 page 44 to ଆସିଲା page 44 Person previous this
wait. The notice on opposite party number 3, Pradeep Kumar As has returned answered with postal notice, postal remark, address he left without instruction. Stop. It is brought to the notice of this court that the said opposite party number 3, in connection with the property involved in the case, has instituted CS number 370/479 of 2023, which is sub judice before the Learned Civil Judge, Senior Civil Judge Baleswar. Stop. Let a copy of the writ petition be filed by tomorrow, which will be sent by the Learned Register Judicial to the court of Learned Senior Civil Judge Baleswar to be served on the plaintiff Sri Pradeep Kumar As, and within a week, and report compliance. Matter will be listed in the week commencing from 9th of December 2024. That's the rest of the matter tomorrow.
I have a small request, my lord. Lord, that matter, I'm sorry, my lord, I'm just disturbing, my lord. That matter adjourned to 2nd December, my lord. Can I just pray, let it be on 3rd December?
Oh, the one for instruction to be taken.
Item 46, my lord.
6.
If it is not inconvenient to my lords, only on 3rd.
46 to 3
So grateful.
Maybe pardon your lordships. Item 54. I have to file a rejoinder, your lordships. So I pray at least 3 weeks time. I had informed the counsel for petitioner.
54.
Lordships.
and counsel submits that he has received the counter claim filed by the opposite party and she intends to file the reasonable affidavit and 2 weeks time may be this matter. কই দিয়েছেন তো
ଆଜ୍ଞା ମୁଁ ଇନଫର୍ମ କରିଛି
ଆଉ ପଛରେ ଆସି ସେ କହିବେ ନା
ନାଇଁ ନାଇଁ କାଲି ବାହାର ହେଇଛି
criminal offense. ମରିଯାଇଛି ବୋଲି ଆଜି ଦିନ ସୋମବାର 25 1800 କେତେ
Pardon mention.
ସରପଞ୍ଚ ଦେଇଛି
Criminal appeal 947 for 2023. Petition is languishing in jail custody 8 years 6 months.
Special notice for orders item number 1
Wait, please, Your Lordship. Your Lordship, the appellant has been in custody since 26/1/2017. And Your Lordship, in the meantime, today at the during the dawn, Your Lordship, the daughter of the present appellant, who is 8 years, has been declared dead.
Oh, this 3005. Have you received a copy of that?
Just now, my lord, received it.
What ground has been taken that?
The appellant's daughter died.
uh, it would be a subjective satisfaction that the learned trial court, you will verify if it is correct after ascertaining through the IAC.
Smile.
Then you will grant him bail for 2 weeks, let us say.
Smile.
Is an application for bail, interim bail, on the ground that the daughter of the petitioner has passed away today. And the presence of the petitioner is necessary for performing the obsequious ceremony. Copy of the interim application has been served on the Land Council for the state. However, it submits that is not able to receive instruction in the matter due to paucity of time. Considering the submission made by the Land Council for the respective parties, the government's taken in the interim application. And the urgency involved in it, we are inclined to grant interim bail for a period of 2 weeks to the petitioner, subject to condition that before accepting the bail bond, the Learned Trial Court shall verify to the inspector in charge of some sort of police station as to whether the government's taken in the intima situation that the younger daughter, the petitioner has passed away today. It is correct or not?
Namely, Tina
Tina Huika.
Huika.
Tina
Huika.
namely Tina Huika.
Tina Huika ko younger daughter?
ନାଇଁ ଇଏ କୋଉଟା ଗଲା?
8 years.
ୟଙ୍ଗର ଗଲା ହେଲେ ଖୁସି ହୁଇକା ହବ। ୟଙ୍ଗର ଗଲା ନା ଏଲ୍ଡର?
Tina Huika 8 ବର୍ଷ।
Tina Huika is 5 years.
ସେ ଲେଖୁଛନ୍ତି ଆଜି ଦିନ ପୂର୍ବାହ୍ନ 3 ଘଣ୍ଟା ସମୟରେ ଟିନା ହୁଇକା 8 ବର୍ଷ ପିତା ଗୋଦା ହୁଇକା ଙ୍କ ଦ୍ୱିତୀୟ ପୁତ୍ରୀ ମୃତ୍ୟୁବରଣ କରି ସେକେଣ୍ଡ ଡଟର।
Youngest daughter is 5 years.
ଦିନ ପୂର୍ବାହ୍ନ 3 ଘଣ୍ଟା ସମୟରେ ସ୍ୱର୍ଗତ ଟିନାଙ୍କ ବୟସ 8 ବର୍ଷ ପିତାଙ୍କ ଦ୍ୱିତୀୟ ପୁତ୍ରୀ କହୁଛି ସେ
ଦ୍ୱିତୀୟ ପୁତ୍ରୀ ସେକେଣ୍ଡ ଡଟର।
ତାହେଲେ ଟିନା ଇଜ ସେକେଣ୍ଡ ଡଟର। ହଁ ଏଜେଡ 5 years
8 years।
ଗୋଟେ ତ 8 years ଗୋଟେ 5 years। ଇଏ ତ 8 years ଲେଖୁଛି।
ଦ୍ୱିତୀୟ ଜେଜେମା ନୁଣ୍ଡା ଗୋଦାଙ୍କ ମା ସହ କରଡ଼ା ବନ୍ଧ ଗ୍ରାମରେ ବାସ
କରୁଛନ୍ତି। ଫାର୍ଷ୍ଟ ହଉ କି ସେକେଣ୍ଡ ହଉ ଆମେ
daughter of the so Tina Huika kal likhta hai na past hai se first second daughter ki hai na the land council for the teacher has produced a certificate issued by the Sarpanch M Patroguda Gram Panchayat dated 25/11/2024. In that respect, which is taken on record. The order be communicated by the land registered judicial to the land trial court to email and on the
additional sessions of Guru.
The land trial court shall proceed accordingly without awaiting for the certified copy of the 2 days order after taking an undertaking from the petitioner council that the certified copy will be produced during course of this week.
Your Lordship, may I pray for little more than 2 weeks because there is another daughter. ଆଉ ଗୋଟେ ବି ଅଛି ତ he's never been out. Much obliged, Your Lordship.
List item number 1.
May I please oblige? And here the appellant has been convicted to undergo RI for life for offense.
In this action, petitioner pray for extension of time in interim bail, Lordship. Lordship, his as per serial list, his mother surgery is conducted on 28, Lordship. So, Lordship, kindly grant 15 days time to 28 November, Lordship. That operation hover, Lordship. Kindly grant 15 days time to.
No, you are granted interim bail,
Lordship.
Why did you do?
We are
there was
filing
no
for
urgency,
extension of time, Lordship.
Then the earlier occasion when he was released from custody on so and so, and the surrender date was fixed so and so, and during the interim bail period, the petitioner brought his mother to so and so, and the doctor prescribed some medicine, and it was advised mother is so and so. There is no other male member. Oh, you have already
taken extension, huh?
Lordship.
Part the land council for the petition, land council for this one. Extension application stands rejected. Yes.
Lordship, just 15 days, Lordship.
If the petitioner doesn't surrender on the date fixed, the London trial court shall take the courtship step to arrest him immediately and take him to judicial custody. Yes.
Item 3.
Communicated by the registrar to the council. Yes.
May please, Your Lordship. My Lord, in CRL number 639 of 2016, ma'am. My Lord, in this case, the petitioner was released on interim bail, my Lord, and due time in surrender on 2/11/2024. I have annexed that in the IA minor annexure 1. Your surrender certificate, my Lord.
When you surrender?
2/11/2024.
Again, why have you come?
Pardon, ma'am?
Why have you again filed here? Recently, you have been granted interim bail for 3 months.
Yes, ma'am.
And you have surrendered this month only on 2/11.
Yes, ma'am.
Again, applied for interim bail.
No, regular bail, ma'am. I applied for regular bail.
Regular bail, yeah. Your application must have been rejected on merit earlier.
No, ma'am.
It was not rejected.
On merit, it was not considered, my Lord. Only grant 3 months.
Yes, just a minute. But we have held that taking into account the nature and gravity of the accusation as per the statement of the victim and also the material available on forum, we are while we are not inclined to release the petitioner on bail on merit. So merit it was rejected, but taking into account your period of detention in judicial custody for more than 7 years, you are granted interim bail.
Yes,
so now again you have approached.
In the meantime, my Lord, other 2 accused person was released on bail, my Lord, by this Your Lord.
Perhaps you are the main accused in that.
My Lord, I am not main accused. Main accused Vishnu Kisan and Amir Pradhan. The allegation against
recently rejected on merit, and you have been granted interim bail. No question of again reconsidering the matter within a short span of time on merit. For that, change in the circumstances is necessary. That is the settled principle, and you have been granted bail. So this is for
surrendering. This is bail for regular bail.
Regular bail, that's right. The IN number so and so, this is an application for regular bail. As it appears on 29/7/2024, while considering the application for bail in this case number so and so, this court, while not inclining to release the petitioner on bail on merit, taking into account the period of detention in judicial custody for more than 7 years and the absence of any chance of early hearing, granted interim bail to the petitioner for a period of 3 months from the date of release. The petitioner has surrendered in the meantime and surrender certificate has been filed. This bail application is again filed to consider the bail application on merit. Since we have rejected the bail application on merit a few months back, we are not inclined to grant the petitioner a release on petitioner on bail on merit. Accordingly, rejected. Yes, next.
My Lord, any time may be given, my Lord, file for.
Yes.
Any time may be given, file for another bail application.
Is there any bar?
No.
Because you had recently considered.
My Lord, this I have permitted to withdraw.
Which way?
Why?
We have already
Was it
passed
passed
the order,
order?
Mr. Counsel. Yes, next.
Item 4.
Decision IACR number 639 of 2016. Yes, item number 4, 2019. order number. So none of the
Admit call for lower court record, but nobody is appearing.
change for
13-5 मध्य नॉन ओरिजिनल राज appearance.
page आसुना
Change
change
for-
will change. number order related order number 1 there.
We'll change it. We'll change it.
Azhar Jamal.
Hmm.
Mrs. Azhar Jamal.
फिर
Jamal.
the sir you have put it on non appears absolutely. And since it's an appeal of the year 2019 and paperwork has been prepared, the official saw a copy of the paperwork from the new council and the matching listed were date they were what hearing. Since some time on the yeah.
Item 5.
भरोसा व्यक्ति agree prisoner petition ಹೊರತಿಲ್ಲ.
उनतीस 7/2019.
Item number 6.
Malad item 6 malad prayer for supply paper book.
You are Mr. R. Panda?
Yes, malad. Malad.
Paperbook has been prepared since long. Why are you not collecting the paperbook? The cause list, after the paperbooks are prepared, there used to be a list given that in these cases, paperbook has been prepared and the councils are requested to collect the paperbook. So,
1 week time. Next week asuma evening time.
Pandal and council is present and he submits that he has not received copy of the paperwork. Let a copy of the paperwork be supplied to him in court. Achito? Let a copy of the interview and the get ready for hearing matter listed. Put a chapter of whatever the date given.
Item 7.
Yes,
My praise the Lord. Last of the Lordship call for the custody certificate based on language in the jail.
yeah, your bail application was earlier rejected on maybe.
Interim bail ता ଦେଇଥିଲେ जो ବାପା ମରି ଯାଇଥିଲେ ସେଇଟା surrender କଲେ.
Now, custody certificate ଆସିବ?
Minor ଆସିନି. Letter has been issued.
ନା ଆପଣ କଣ ରେସ୍ପନ୍ସ କରୁନାହାନ୍ତି?
अरे 2 ଥର ପଠା ହେଲାଣି. 2 ଥର ପଠା ହେଲାଣି.
କାହିଁକି 2 ଥର କଣ ପାଇଁ ପଠେଇବେ? ଆପଣଙ୍କର କିଛି ନାହିଁ କି ୱିଙ୍ଗ ନାହିଁ କି? ଆପଣଙ୍କର ଏଠୁ ଫୋନ କରିବେ ସେ ତା ପରଦିନ ଆଣି କଷ୍ଟଡି
Day after tomorrow morning.
The higher number to answer for bail. The land council for the state seeks some time to produce the custody certificate. He submits that after passing of the order dated 4/11/2024, so also 19/11/2024, twice later has been issued to the concerned jail superintendent to submit the custody certificate. The matter will be listed on 27th of November 2024. The concerned jail superintendent shall appear through virtual mode before this court to apprise this court as to why he has not responded to the letter of from the office of the advocate, learned advocate general, and in that process is creating hurdle in the administration of justice, and why contempt of court proceedings shall not be initiated against him. Copy of the order be handed over to the land council for the state in course of the day. Yes.
Item 8.
May it please your lords. Lifer and in custody since 29/10/11. Last time, once your lordship had granted interim bail for 1 month, your lordship had called for a report whether he misleaded it or not.
Yes. There is an order on 4/11/2024 that you are to obtain the report from IIC Gopalpur Police Station regarding the conduct of the petitioner while he was on interim bail.
Many report not been received.
Ask the learned advocate general to appear through virtual mode. I'm passing it over. Yes.
Item 9.
May I please? Miller, the petitioner has been convicted under section 302 and sentenced to undergo RI for life. Your lordship, the prosecution allegation against the present petition is that as per the charge sheet, there is a tussle between the petitioner and his wife, and in the meantime, the wife of the petitioner fell down and they struck to a wall. Thereafter, the petitioner, as per allegation, murdered the.
What is the date of custody?
Milord 1/1/2017.
You have after
no direct
2/1/2/1
evidence.
2017.
Milord.
So that means it is 7 years.
Milord.
7 years, 10 months. Okay.
Milord.
What is the allegation? Come to paragraph number 2 of the judgment. Let us
Milord.
see
The prosecution allegation is that the Tapan Kumar Singh lodged an affair before the police station, that his cousin sister Sasmita has married to the accused Rajendra Singh, the present petitioner, on 1/1/2007 at 6:30 am. He met Rajendra Singh near Raghunath Nagar auto stand. The accused Rajendra Singh greeted him with a happy new year and disclosed before him that he has committed murder of Sasmita. Hearing so, the informant informed the fact over phone to the family members of Sasmita, who immediately reached near the house of the accused. When they knocked the door, the accused did not open the door. Thereafter, they called on the police through phone numbers also. PCR van reached there. After reaching a PCR van, the accused opened the door. They entered into the house and found the dead body of the Sasmita lying on the backside room of the house of the accused, with bleeding from her face, neck, mouth, and injury.
on her back and eyebrow. On being asked, the accused disclosed that he has killed the deceased due to dispute for money. On this allegation, investigation has. That is the allegation, my lord. Your lordship, in the charge sheet, your lordship, in charge sheet, the fact of the case, my lord, Rajendra Kumar Singh returned and his wife.
You
and
are staying with your wife,
my lord,
and your wife's dead body was found in your house where you are staying. And the number of injuries were noticed on different parts of the body. And with that doctor is PW17.
my lord.
He conducted postmortem examination, and the evidence is at page number 26.
My lord.
It is discussed that
Your lordship, may kindly see the running page 28, judgment 15, my lord. Paragraph 9. There is
neck muscles are confused with extravagation of blood to the surrounding soft tissues. Found all the internal organs were intact and congested. The injuries found on the body of the deceased are antemortem in nature. Injury number 1 is the pressure abrasion, consistency with the ligature mark of strangulation, and laceration of contusion could have been by hard blunt trauma. He opined that the death of the deceased is due to asphyxia as a result of compression of neck resulting from manual strangulation. So, manual strangulation द्वारा आपणकर दौड़ीरे लिगेचर रे हाँ से जहाँ भी हो लिगेचर रे ताकू तंटी चिपाई मराइची, and you are the person who was present with the deceased and you are the husband. So what is your case?
Lord, the case is that there is, your lordship may kindly see page 28.
And apart from that, as it appears from the FIR,
yes,
you have made extrajudicial confession.
Yes, only extrajudicial. There is no eyewitnesses to the occurrence.
Where from we get eyewitness?
Yes.
The occurrence took place inside your room.
Yes,
and you and your wife were staying. Your wife was found dead.
Yes.
And the cause of death is manual strangulation, homicidal in nature. And there, where from you get the eyewitness to the occurrence?
Yes, madam. Only extrajudicial confession.
Again, you are going to that. How have you discharged your burden under 106 of the Evidence Act? It was within your special knowledge as to how your wife died. You are to say.
No, there is no motive and intention, madam. Knowledge also that.
You are putting a ligature around the neck of your wife, pressing it and killing her, and you are saying that you have got no motive. Very strange.
Lord, I know. Actually, the direct
just he was trying to know what will happen, no? On tying the sling. Yeah.
There is a demand from the money from the petitioner, and there is a tussle between them for meet the New Year's and birthday ceremony of the two minor children. Thereafter, sudden spur of moment.
Who said this?
Fell down.
Who said this? All story or what?
Charge sheet has already been.
Charge sheet nahi, evidence kono? Evidence ta charge sheet ta evidence.
What is your case in the accused statement?
Accused statement
come to denial or you have
deny.
Yes,
complete denial. Completely denial.
It is not your case that any third person committed the crime.
No, two minor children is there, and all the witnesses are the interested witness. On the basis of the interested witness, family member of the deceased, convicted. No criminal antecedent. The first offender. Other accusation.
302 re first offender. Achi.
And that the judgment is said there.
No.
Your lordship.
What do you mean by this first offender in a 302?
Yes, the judgment. The convicted.
No, you mean to say that several other murder has to be there?
No.
Then only.
Your plea in the accused statement, question number 70.
Yes, madam.
Have you got to say anything more about the case? ମୁଁ ସକାଳେ 9:30 ବେଳେ ଘରକୁ ଫେରି ଦେଖିଲି ମୋ ସ୍ତ୍ରୀ ମରିକି ପଡ଼ିଛି। ମୁଁ ତପନକୁ ଖବର ଦେଲି। ସେତେବେଳେ ତପନ ମୋ ଘର ପାଖରେ ରହୁଥିଲା। ତପନ ଘରେ ନଥିଲା। ମୁଁ ତପନକୁ ଫୋନ କରି ଡାକିଲି ଆଉ ସସ୍ମିତା ମରିବା କଥା କହିଲି। ବାସ୍ this is your but you have not stated as to how your wife died. You have got two small children.
Yes, my lord.
ସେମାନଙ୍କର ବର୍ତ୍ତମାନ ପୋଜିସନ କଣ କରୁଛନ୍ତି ସେମାନେ?
ପଢୁଛନ୍ତି ସ୍କୁଲ।
ଆଉ କିଏ ଘରେ
ସ୍କୁଲରେ ପଢୁଛନ୍ତି। Permanent resident of the Khapuria, lenience भी humanity ground.
Humanity.
यार आंटीसीडेंट आनंतु ଝିଅଟା ସେ ଛୁଆ ଦିଟା କଣ କରୁଛନ୍ତି ତାଙ୍କର ଷ୍ଟାଟସ ନେଇକିନା ଦିଟା ପିଲା ତ
ଆଜ୍ଞା
IN number so and so this is an application for the the land council for the state seeks some time to obtain the criminal antecedent instruction, take instruction about the criminal antecedent if any against the appellant, so also the status of the two children of the deceased out of this matter week after children go to
My lord, Anul, I vote on virtual mode.
ये टाको लाइव स्ट्रीमिंग तो ऑफ कर दिया as for the order dated 4/11/2024, so also the order dated so and so. Letters have been issued to the IIC Gopalpur Police Station for giving for submitting a report regarding the conduct of the swan. So petitioner filed on interim bail, but no response has been received. The Learned Advocate General, appearing through virtual mode, submitted that he will see to it that the matter, the information is received by tomorrow. By tomorrow, this matter on 27th of November 2024. Out of matter is your contempt contempt of portion of category Learned Advocate General appears and so on so କରିକିନି ତାକୁ ମଧ୍ୟ ରଖିଦେବେ। ଏଟା କେତେ ନମ୍ବର ଆଇଟମ? 7 ନମ୍ବର ଆଇଟମ। ସେଟା କିନ୍ତୁ ସେ ପହର ଦିନକୁ ରହିବ, but state of contempt of category clearly.
Deeply obliged.
Yes.
Item number 10.
Please, I have already filed IA 24224 for extension of the interim bail matter.
You have been released on interim bail by order dated 13/8/2024. On what ground? Because we are not inclined to grant you bail on merit. That is why, taking into account your detention period, we granted you interim bail, right?
My lord.
You have in the meantime surrendered, or you have not surrendered?
No, my lord. The applicant already custody, my lord. He has not released today now. The applicant already custody, my lord.
No, after the interim bail, he availed it.
No.
He did not avail.
No.
So he has not yet been released.
No, my lord.
What happened?
In the meantime, the present applicant changed the counsel. My lord, I came to know.
Our query ta hoji, ଆପଣ ସିନା interim bail ରେ ଯାଇଥିଲେ, କଣ ଗୋଟେ ଦରକାର ପଡିଲା ଆଉ ଟିକେ extension କରିବା ପାଇଁ ଆପଣ extension ମାଗିଥାନ୍ତେ। ଆପଣ ତ ମୂଳରୁ ଯାଇନାହାନ୍ତି, ଆଉ extension କଣ ଦିଆଯିବ?
Let him be released first.
ଆପଣ ଏଇ order ଟା ଆପଣ ବି ଆଜି ନେଇ produce କଲେ, ଆପଣ 3 ମାସ ଯାଇପାରିବେ। ବେଲ order ତ ଅଛି, ତ order ତ ନାହିଁ, ଏତିକି ଦିନ ଭିତରେ ବେଲ ବଣ୍ଡ ଦେଲେ ଆପଣ ଯିବେ, ନଚେତ ନାହିଁ। ତ ଆପଣ extension of କାଇଁ ଫାଇଲ କରିଛନ୍ତି? extension of interim bail
wrongly, maybe broken.
IA number 1 is an application for extension of interim bail. Since the petitioner has not been released on interim bail as stated by the Learned Counsel for the petitioner
pursuant to the
order dated 13/8/2024 passed in IA number 170 of 2023. There is no question of extending the interim bail order. Therefore, this IA stands dismissed. The petitioner is at liberty to avail the interim bail order as per the said order dated 13/8/2024 passed in IA number 1. Yes, next.
Yeah, 49.
From your side, somebody
Rakis Behra, ma'am.
Please write it out and pass it. You have got power in this case.
Madam.
Have you got power in this case? Appeal.
No.
If you have
No,
got no power, then you have to file the consent memo. How can you argue a criminal appeal without the consent of the previously engaged counsel? You have not filed V-Nama.
No, not yet.
So any counsel, either from Mr. Naik or from Mahapatra or Mr. Hota, that consent memo is to come on record.
I'll file it, madam.
Because
You are not in record at all, I think.
because
No.
tomorrow he may come that I have not authorized this counsel to argue the matter. How did he argue and how the court permitted him to argue the matter?
Mine.
Are you following?
I mind.
Yes, so that is to be done.
So the three lawyers now, Mr. Naik has come to the other side.
Mine.
Mr. S. Mahapatra and S. Hota.
Mine.
They are the other lawyers.
Mine.
And your Vinama doesn't appear at all.
My lord. I'll get a consent, my lord.
No.
So, Mr. Naik, can you give him consent?
Yes, yes, madam.
He has to.
No, I'm just asking him. So,
My lord.
so matter should be regular.
My
Yes.
lord.
We can't take
In course of the day,
Okay. So, the matter and RAKESH, then
BEHERA.
BEHERA.
Yes, madam.
But you are not writing that last A. You finished it with R. RAKESH. And Mr. Pradhan,
My lord.
you are to argue, okay. So, Pradhan. Let's see. Okay, it's a single appellant.
My lord.
And he alone faced trial.
My lord. Single appellant.
Offense is 302.
302, my lord.
302. Please come to the FIR.
My-
See the.
My FIR is at page number 48. Written FIR, my lord.
Yes, yes. समझो. So come. If one thing that you do, judgment or yes.
My lord. Page number 48. The FIR, my lord, of the paper book, my lord. ନିବେଦନର କାରଣ ଏହି କି ମୁଁ ଶ୍ରୀମତୀ ସମ୍ବରୀ ବାଗ ସ୍ୱାମୀ ଯୋଗୀ ବାଗ
जो ଯାହାର ଆସିବ PW କହିଦେବେ.
My lord.
ସମ୍ବରୀ ବାଗ PW କେତେ?
PW 11, my lord. Swami Jogi Bag, the deceased, my lord.
अच्छा.
My lord. थाना कुंडेगोला जिला देवगढ़ एंड गतकाली तारीख 27/4/2012 तारीख ऊपर बेला मो स्वामी आम भेणे लोचन उद्धव द अपेलेंट माय लॉर्ड उद्धवरଙ୍କ ଘରକୁ ଯାଇଥିଲେ ଏହାର ପ୍ରାୟ ଅଧ ଘଣ୍ଟା ପରେ ଲୋଚନ ଉद्धବର ଇଙ୍କୁ ରାଜହଂସ ଓ ମୋ ସ୍ୱାମୀ ସହ ଇଙ୍କୁ ରାଜହଂସ ଇଜ ନଟ୍ ଆନ୍ ୱିଟନେସ୍ ମାଇ ଲର୍ଡ ଇଙ୍କୁ ରାଜହଂସ ଓ ମୋ ସ୍ୱାମୀ ମିଶି ଆମ ଘରକୁ ଆସିଲେ ଓ ଘର ବାରଣ୍ଡାରେ ବସିଲେ ଇଙ୍କୁ ରାଜହଂସ ମୋ ଦେଢଶୁର କୁଲ୍ଲବାଗଙ୍କ ଝିଅ କୁଲ୍ଲବାଗ ଇଜ ମାଇ ଲର୍ଡ ୱିଟନେସ୍ ନମ୍ବର 5
PW5
ମାଇ PW5 ଇଙ୍କୁ ହଁ କୁଲ୍ଲବାଗଙ୍କ ଝିଅ ପାଞ୍ଚାଳିକୁ ଭଲ ପାଇ ସ୍ତ୍ରୀ ହିସାବରେ ରଖିଥିବାରୁ ଆମେ ଇଙ୍କୁକୁ ଭଲ ପାଉନଥିଲୁ ପାଞ୍ଚାଳି ହାଜ ନଟ୍ ବିନ୍ ଏକ୍ସାମିନ୍ଡ ଆଜ ୱିଟନେସ୍ ମାଇ ଲର୍ଡ କିନ୍ତୁ ଲୋଚନ ଉद्धବର ସେହି ଇଙ୍କୁକୁ କହିଲା ଯେ ସେ ତାକୁ ତାର ନିଜ ଜାଗାରୁ ରହିବା ପାଇଁ ଜାଗା ଦେବ ଓ ସେ ଘର ବନେଇ ରହିବ ଏହା ଶୁଣି ମୋ ସ୍ୱାମୀ ଲୋଚନ ଉଦ୍ଧବରକୁ ତୁ କାହିଁକି ଇଙ୍କୁ ରାଜହଂସକୁ ଜାଗା ଦେବୁ ବୋଲି ଯୁକ୍ତିତର୍କ ହେଲେ। ଲୋଚନ
ବୁଝିଗଲାଣି।
ଏହା ଶୁଣି
ଏହା ଶୁଣି ତୁ କାହିଁକି
ସେଇ ରୂପକୁ କହିଲା ଯେ ସେ ତାକୁ ତାର ନିଜ ଜାଗାରୁ ରହିବା ପାଇଁ ଜାଗା ଦେବ
ସେ ଘର ବନେଇକି
ଓ ସେ ଘର ବନେଇ ରହିବ। ତାପରେ କଣ ହେଲା?
ଏହା ଶୁଣି ମୋ ସ୍ୱାମୀ ଲୋଚନ ଉଦ୍ଧବରକୁ ତୁ କାହିଁକି ଇଙ୍କୁ ରାଜହଂସକୁ ଜାଗା ଦେବୁ କହି ଯୁକ୍ତିତର୍କ ହେଲେ। ଲୋଚନ ଉଦ୍ଧବର ଓ ଇଙ୍କୁ ରାଜହଂସ ଆମ ଘରୁ ପଳାଇ ଗଲେ। ମୋ ସ୍ୱାମୀ ଆମ ଘର ପାଖରେ ଥିବା ମହୁଲ ଗଛ ମୂଳ ଛାଇରେ ବସି କେନ୍ଦୁପତ୍ର ବାନ୍ଧୁଥିଲେ। ଅଳ୍ପ ସମୟ ପରେ ଲୋଚନ ଉଦ୍ଧବର ଗୋଟିଏ ଟାଙ୍ଗିଆ ଧରି ତାର ଘରୁ ବାହାରି ଆସି ମୋ ସ୍ୱାମୀଙ୍କୁ ମାରିଦେବ ହାଣିଦେବ ବୋଲି ପାଟି କଲା। ବାରମ୍ବାର ଏପରି ପାଟି କରି ଧମକାଇବାରୁ ମୋ ସ୍ୱାମୀ ଲୋଚନକୁ ଗାଳି ଗୁଲଜ କର ନାହିଁ ବୋଲି କହୁଥାନ୍ତି। ମୁଁ ଏତିକି ବେଳେ ନଳକୂପରୁ ପାଣି ଧରି ଘରକୁ ଫେରୁଥାଏ। ଲୋଚନ ଟାଙ୍ଗିଆ ଧରିଥିବାର ଦେଖି ମୁଁ ଭୟରେ ସେଠାକୁ ଦୌଡ଼ିଗଲି। ବଡ଼ କଷ୍ଟରେ ଲୋଚନକୁ ଛକାଛକି କରି ଲୋଚନ ଉଦ୍ଧବର ହାତରୁ ଟାଙ୍ଗିଆଟି ଛଡ଼େଇ ଆଣିଲି। କିନ୍ତୁ ଗୋଟିଏ ପାଞ୍ଚଣ ବାଡ଼ିରେ ମୋ ସ୍ୱାମୀର ମୁଣ୍ଡକୁ ଲକ୍ଷ୍ୟ କରି ଲୋଚନ ଦୁଇ ପାହାର ପିଟିଲା। ମୋ ସ୍ୱାମୀର ମୁଣ୍ଡ ଫାଟି ଭୀଷଣ ରକ୍ତ ବାହାରି ତଳେ ପଡ଼ିଗଲେ। ମୁଁ ପାଟି କରିବାରୁ ମୋ ଦିଅର ଦୁସିଆ PW1 ମାଇଲ ଦୁସିଆ ଘଟଣାସ୍ଥଳକୁ ଦୌଡ଼ି ଆସିଲେ। ମୁଁ ଟାଙ୍ଗିଆଟି ଦୁସିଆକୁ ଧରାଇ ଦେଲି। ମୋ ସ୍ୱାମୀକୁ ତଳୁ ହାତ ଧରି ଚଲେଇ ଆଣି ଘରକୁ ଆସିଲି ଓ ଘର ସାମ୍ନା ବାହାର ଦ୍ୱାରରେ ଗୋଟିଏ ପଟିଆରେ ଶୁଆଇ ଦେଲି। ମୁଁ ତାଙ୍କୁ ଜଗି ରହିଥିଲି। ରକ୍ତ ଭୀଷଣ ବାହାରୁଥାଏ। ଆମେ ଗରିବ ଲୋକ ହୋଇଥିବାରୁ ଏବଂ ଗାଡ଼ି ମଟର ସୁବିଧା ନଥିବାରୁ ସକାଳେ ଡାକ୍ତରଖାନାକୁ ନେବୁ ବୋଲି ଚିନ୍ତା କରିଥିଲି। କିନ୍ତୁ ରାତି ପ୍ରାୟ 4ଟା ବେଳକୁ ସ୍ୱାମୀ ପାଟିତୁଣ୍ଡ କିଛି ନ କରିବାରୁ ମୁଁ ଭୟରେ ମୋ ଦିଅର ଦୁସିଆ, ଦେଢ଼ଶୁର କୁଲ ଓ ଅନ୍ୟମାନଙ୍କୁ କୋହଳା କରି ସେମାନେ ଆସି ଦେଖିବାରେ ମୋ ସ୍ୱାମୀ ମରିଯାଇଛନ୍ତି। ଦୁସିଆ has been examined as PW1 ମାଇଲ। PW1 କୁଲ PW5 ମାଇଲ। ମୋ ସ୍ୱାମୀଙ୍କୁ ଆମ ଗାଁର ଲୋଚନ ଉଦ୍ଧବର ପିତା ରାଜ ଉଦ୍ଧବର ପାଞ୍ଚଣ ବାଡ଼ିରେ ମୋ ସ୍ୱାମୀର ମୁଣ୍ଡରେ ଦୁଇ ପାହାର ପିଟିଥିବାରୁ ତାଙ୍କର ମୁଣ୍ଡ ଫାଟି ଭୀଷଣ ରକ୍ତ ବାହାରି ମୃତ୍ୟୁ ହୋଇଛି। ଏହି ଘଟଣା ଆମ ଗାଁର ଅନେକ ଲୋକ ଜାଣିଛନ୍ତି। ଏହି ଘଟଣା ଗତକାଲି 27/4/2012 ଉପରବେଳା ସମୟ ପ୍ରାୟ 5ଟା ବେଳେ ଘଟିଛି।
Who are the eyewitnesses to the occurrence?
Eyewitnesses, my lord, PW11, that is the wife of the deceased, my lord.
ଆଉ ଏଇ ଯୋଉ ଏମାନଙ୍କର ସାମ୍ନାରେ ହେଲା ବୋଲି କହୁଛନ୍ତି?
Well, Dusya Bagh is the immediate post-occurrence witness, my lord, who lifted the deceased along with the wife of the deceased, my lord.
No. By the time the strike was given by the
appellant,
by the appellant, the tangia was given to her.
To Dusya, my lord.
The wife of the deceased gave the tangia to Dusya. That means he was present.
That he states that he gave in the FIR. He states that he gave it at that moment, but later she says
in the evidence.
Later in the evidence she says that.
କାରଣ ଏଠୁ ଯା ଜଣା ପଡୁଛି ଦୁସିଆ ବି ମାନେ ଥିଲା ଘଟଣା ବେଳେ। But
Dusya also stated in the evidence that he is stating as for the
eyewitness is PW11.
PW1.
PW1.
Dusya.
He is also another witness. Who was is a post-occurrence witness.
Post-occurrence witness.
Okay. And who is the doctor?
Doctor is PW9, my lord.
आगे पढ़े आसंतु 9 को बाकी जो
my lord, this is a case where I am not praying for the acquittal of the accused. I am the conversion of the sentence.
That is exactly the reason we asking you to come to that PW9's evidence.
PW9. That is page number 81, my lord. May I read, my lord? On 28/4/2012, I was in my present post. On police requisition, I conducted post-mortem examination of Jogi Bag, son of late Jhantu Bag of village Mahasingh, PS Kundheola, district Devgarh, and found as follows. Internal examination. The deceased was strong and stout. Rigor motive was present on all four limbs. Yes, and mouth was forth from the nostril and mouth. Froth was inside. Postmortem abrain over the body, arms on right forearms. External examination. Abrasion of
size.
One. Mine.
এটা হচ্ছে বোধহয় right
Elbow joint.
Mine.
Upper up right elbow joint.
My lord.
Secondary, say
That is right elbow joint.
Thirdটা হচ্ছে right elbow joint.
The fourth injury is that proved to be fatal, my lord.
Lacerated injury.
The bone deep on the left.
Left parietal region to the midline.
On dissection, external hematoma of size over the left parietal temporal region, linear fracture of left parietal bone of so and so length. Rest of the viscera were intact and tagged. Opinion, my lord. The injury noted above were antemortem in nature. The cause of death was due to head injury and hemorrhage, possible by blunt and hard object. Time since death within time since death within 24 hours of PM examination. This is my said report being marked as Exhibit 5. This is my signature on the marked as so. On 30th April 2012, I examined the weapon of offense to answer the query on the same. The injury noted above, the dead body of the deceased, Jogi Bag, was possible by the weapon of offense. As to query number 2, my opinion was on use of sufficient force, the stick concerned could have been broken down. As to query number 3, my opinion was that the offense was strong enough in ordinary course of death to cause death of a person. In answer to query number 4, I have not noticed blood stain, mark of blood stain. I am noticed blood stained and marks of 4 cases on the weapon of offense concerned, and has suggested blood stain.
Please go continue.
Man. And has suggested for the chemical examination. This is my said report being marked as so and so. Cross examination by the defense. In case a man in a state of drunkenness, the above injury might have been caused by fall from a higher place on one hard surface. In absence of physically seen the weapon of offense concerned, in court today, I cannot
about the correctness of the opinion
regarding the said weapon of offense. The suggestion and not answer. The question from the court: in absence of the production of the said weapon of offense inside the court today, can you state it for certain that the above injury, that the said weapon of offense was caused death of the concerned, possibly due to the deceased concerned, possibly due to the injury caused by the said weapon of offense on the person of the deceased. In absence of physically seen to the state of weapon of offense inside the court today, I cannot certainly state about the cause of death due to the weapon of offense produced before me.
Okay, now we come to the eyewitness PW 11. You said the
wife of the deceased. Ma'am, I am the informant in this case, whereas the deceased was my husband. I had prior acquaintance with the accused named Lochan Udavar, who stand related to me as being the husband of my husband's sister. More than 1 year back, the alleged occurrence took place nearby our paddy land on the land of Madhu. It was an afternoon on that date. By then, I was bundling of kendu leaves. Just during then, the accused, along with my husband and one named Rinku, came to my house and sat there. The said Inku had kidnapped my husband's elder brother's daughter. The same accused Luchan promised to give homestead land to said Inku in absence of providing any such land by husband in his favor. After saying the same, my husband, both of them got up and left our house. After they had left our house, my husband was bundling of kendu leaves. I had been to draw water. Just during then, accused Luchan came out from his house with an axe in his hand, and by saying Mari Devi, etc., ran towards my husband. By then, I was a short distance from that spot. After seeing two accused running towards my husband, threw out the water in my hand and ran towards him. While the accused was about to give a blow, I raised hand and blunt the same and snatched away the axe from the hand of the hand of the accused. Still then, both the accused and my husband went out tussle with each other. Just during then, the wife of the accused, who was standing near there with one body in her hand, handed over the same in the hand of the accused. After getting hold of that body in his hand, the accused gave blows the same on the head of my husband.
It takes a lot of time to corruption.
Yes, sir.
The accused gave blow the same on the head of my husband. That became profuse bleeding during the same. On seeing the same, my husband's younger brother named Dasia came to the spot and snatched away the axe from my hand. My husband also fell down at the spot. After my husband's younger brother came to the spot, the accused left the spot. He also left that body in his hand. We took my husband to our house and laid him over a mat on the ground. As it was night time during then, I remained in my husband and could not take him to the hospital. My husband's younger brother kept the axe in his house. After a few hours, I took a sleep and woke up by about dawn time. On reaching of, I could profuse bleeding from the nostril of my husband, and I ran husband younger brother and to my husband elder brother also, who immediately came to my house and suspected my husband being dead during there. Then the doctor was sent for. On checking of, he declared my husband dead. One fellow villager named Narottam Pradhan wrote down the affair contents as per the instruction of my husband, younger brother. I also joined with him in given instruction to the said Narottam Pradhan. After he read over the contents of the written affair towards he became confirmed the writing down of the said contents as per instruction, after which I gave my thumb marked over the said written down affair. Cross-examination by the defense. Panchali is my husband's elder brother's daughter. My husband's elder brother name is Kolha. Inkut, who is of our caste. Both of them were in love with each other and finally went to the house of Lochan, who promised to give homestead land in their favor to help them settle down. Inku is Kawad by caste, whereas Lochan is Kisan by caste. It is a fact that he said Lochan also tried to pursue my husband, his elder brother and younger brother to cooperate with him to help Panchali and Inku settle down as per his assistance. My husband and Lochan exchanged hot words with each other. It is not a fact that both my husband and brother my husband and Lochan exchanged hot words with each other. It is not a fact that both my husband and brother threatened the accused Lochan to not give any homestead land in favor of Panchali and Inku, and also threatened him to drive him out from our village. It is not a fact that my husband regularly take liquor, but on festival occasion joined with villagers. It is not a fact that we consumed kusuma to ward off extreme summer heat. It is not a fact that my husband in fact has threatened the accused on the date of occurrence and also chased after him to kill on the said date. But during course of the chasing after the accused had fallen down on the ground on his own, and during
Course of
the same had hit over a piece of stone on his head, causing bleeding injury, and had succumbed the said injury itself to breathe his last. Even though the police had been to our village on the next date of the commission of the alleged occurrence, I had not been examined by the police during then. In total, about 10 people came and responded to the hearing of shouting on the date of occurrence. The accused got away body in his hand. It is not a fact that I had not stated before the police that Luchan's wife had held one body in their hand and handed over the same in the hand of the accused, and that the accused given repeated blows with the same on the head of my husband and caused profuse bleeding to cause him fall on the ground. Fall down on the ground. It is not a fact that my husband could survive if promptly given medical treatment after sustaining injury in the hands of the accused. My husband walked on his own to go to our house. It is not a fact that my husband in fact was assaulted
by the accused.
By the accused. That means of Panchanbadi.
By means of Panchanbadi.
By means of Panchanbadi, and that while the accused was attempting to save himself by snatching away that Panchanbadi from the hands of my husband, it had landed on the head of my husband and caused bleeding injury to cause his death. It is a fact that I had gone water to a space about 200 meters. It is a fact that I had not at all. It is a fact that I had not at all seen as to how my deceased husband.
It is a fact that I had not at all seen.
I had not at all seen how my deceased husband had
met with death
and what actually caused his death, and that I am deposing falsehood.
ଆପଣଙ୍କ ସଜେସନ ଗୋଟେ ପ୍ରକାର, ଆପଣଙ୍କର ପ୍ଲି ନେଇଛନ୍ତି ଗୋଟେ ପ୍ରକାର। ଡିଫେନ୍ସ ପ୍ଲି ଯୋଉ ନେଇଛନ୍ତି ଆକ୍ୟୁଜ ଷ୍ଟେଟମେଣ୍ଟରେ ପେଜ 59 ଇଣ୍ଟରନାଲ ପେଜ ଯୋଉ ରହିଛି କଣ କହିବାକୁ ଚାହୁଁଛନ୍ତି ଯୋଉଟା ପଚରା ହଉଛି ଲାଷ୍ଟ କ୍ୱେଶ୍ଚିନ୍, ମୁଁ ଯୋଗୀକୁ ମାରି ନାହିଁ
somebody
ନିରାଶ କଣ ଉଦାହରଣ ମିଛ ମର୍ଡର କେସରେ ମତେ ଫସାଇଛନ୍ତି, ଯୋଗୀ ମଦ ପିଇ ମରିଛି। ଏଇଆ ହଉଛି ଆପଣଙ୍କର ପ୍ଲି। ଏଠି ଅଲଗା ଟାଇପ ର କେସ୍ ଆପଣ ପୁଟ୍ ଫୋର୍ଥ କରୁଥିଲେ, ସଜେସନ ଯୋଉ ଦେଇଛନ୍ତି। ବାକି 1 ନମ୍ବର ସାକ୍ଷୀ କଣ କହିଲା ଆପଣଙ୍କର, ଯୋଉ କହିଲେ 2 ଜଣ ସାକ୍ଷୀ
page 60 I know the accused standing inside the dock named Lochan Udavar, who is my elder sister's husband. Who is my elder sister.
Proceed.
I also know the deceased named Jogi Bag, who is my natural elder brother. I know the informant named Sambari Bag, who is my deceased elder brother's wife. About 7 months back, the alleged occurrence took place in the house of the deceased and of the accused. By then, it was about 4 p.m. to 4:30 p.m. in the afternoon. Just during then, I was bundling the kendu leaves in my house. At that time, I heard shoutings from outside, followed by the informant uh, crying out for help. On listening to the same, I came out from my house. I saw the deceased lying down on the ground.
Lying কোথায় হচ্ছে? Falling down. Falling down, lying down.
Falling down, lying.
আচ্ছা।
Falling down, lying down on the ground with bleeding injury on his head. I further saw the accused standing near him with a body in his hands. Thereafter, the informant and wife lifted the deceased to his wife having bleeding injury on his hand. Due to on his head. Due to want of conveyance, we could not take him anywhere in that night within 11 p.m. to 12 o'clock in the night. 2. The deceased had breathed his last. Both deceased and the accused were pulling on well with each other, proceeding commission of the alleged occurrence. I do not know as to what was the real reason for which the accused had done away the deceased. Had done away with the deceased. Cross-examination by the prosecution. It is a fact that I had been examined by the police in connection with this case. It is a fact that I had stated these lines before the police being marked as X. It is a fact that I also stated these lines before the police being marked as so-and-so. Cross-examination by the defense. It is not a fact that the spot of occurrence is about 1 kilometer apart from my own house. It is of a distance of within half kilometers from my house. It is a fact that on being called by my sister-in-law at my house, I could go out in my house to the spot of occurrence. It is not a fact that the spot of occurrence is a stony place. It is a paddy land only. By then, the harvesting of paddy had already been completed. On that land was also completely dried on hard. By the time I had reached at the spot of occurrence, only my deceased brother and my sister-in-law were found present there. Had we taken our deceased brother immediately to the hospital within 4:30 p.m. on that date, he could have had his chance of survival for the same. At times, we daily wages used to consume particular type of alcoholic substance to mitigate our physical strength. I cannot say for myself if my deceased brother was in that state to himself on the said date. I had not seen if my deceased had sustained bleeding injury on his head by falling down on any stone in his state of drunken on the said date. It is a fact that on hearing from the mouth of my sister-in-law only could I state about the grudge in between the deceased and the accused before the police proceeding the commission of the alleged offense. It is a fact that I had no personal knowledge regarding the commission of the alleged occurrence itself, and that my total evidence given today is mere hearsay. It is not a fact that I am taking the shave of the death of my husband brother, my deceased brother, to come in deposed to falsely against the accused.
Okay, so that means the main blow is given on the head.
Head, my lord.
And he was having first a sharp cutting weapon with him that was taken away by the PW11.
Mine.
Then he assaulted by means of lathi, right?
Panchon body.
And that occurrence took place in the afternoon.
Mine. About 4 to 4:30.
4 to 4:30. But he was not taken to the hospital.
No, mine.
And on the next day, his dead body was found because the wife also slept, and next day he did not
At
got
about
up, and that is how the dead body was found.
Mine.
So, what is the distance of the? Is there anything that what is the nearest hospital?
Police station, hospital, and
nearest hospital, nearest police station. Anything there?
There is no evidence to that extent on record, my lord.
Because he was given that blow on the head. Apart from those abrasion, it's all right, but one blow on the head was given.
My
But most important thing is that he was not taken to the hospital.
my
So
If it
timely
had
medical
such a
intervention.
distance that it would not have been possible on the part of this person to take him to the hospital.
there is also
That
evidence
he's
that
explaining that we don't have any means to take them, take the
there is also
that he has
evidence that
stated.
he the deceased walked on his own to the house, my lord.
Mhm.
There is evidence that the deceased walked on his own after the blow. The deceased walked on his own to the house.
Not walk down. He
No,
was
no.
made to walk to
With
the
the
home.
support of
He was taken to the.
He was
that is
taken
the
by foot. He was taken to the
my
home, and true that the timely medical intervention has not been given.
my
That is there.
he. There is some material that there was some kind of quarrel between the
well,
two.
my lord. On the
And
same day, immediately before that incident, my lord, there was a quarrel that one Inku Rajhans, he had fled with the daughter of the
elder brother of
elder of the deceased, my
elder
lord.
brother daughter.
So this particular appellant was suggesting that let them settle. They were not in favor of that. So he said that I will give a plot of land out of my homestead land and let them settle. So that was protested by the deceased, my lord.
Because they were not
They are not happy that
happy with the that
Relationship.
relationship or fleeing away and getting married to that.
Mine.
They were so that is the reason why some quarrel ensued.
Mine.
And
So, there was no previous enmity. There was no previous. In
no,
fact,
previous enmity was not there. And even though he was having a sharp cutting weapon and quarrel started as it appears, but he did not try to
Use
give any
that.
blow.
Use that.
no overt act. No overt act.
Then this lady snatched away or took away. Then
A Panchan body that was lying there only.
what is the that stick was seized from?
My lord.
What is the seizure list? What is the length of that?
That is there, my lord.
What a panchano body. Acha, that is exhibit
105, my lord.
No, exhibit 9 naga. Exhibit 9 exhibit 9 ଅଛି ଗୋଟେ ପାଞ୍ଚଣ ବାଡି ଯାର ଲମ୍ବା ହଉଛି 59 ସେଣ୍ଟିମିଟର ମଝି ଅଂଶରେ ବୁଲାଇ
Not such a.
ଭାଙ୍ଗି ଯାଇଛି 69 cm ବଡ ଖଣ୍ଡ ହବ
Sufficient to give force.
ପାଞ୍ଚଣ ବାଡିଟା କୋଉଠି ପଡିଥିଲା ମିଳିଲା କୋଉଠି
ପାଞ୍ଚଟି ସେଇଠି ପଡିଥିଲା at the spot of occurrence.
ଆଉ ସେ ଯୋଉ evidence ଟା ସେ ଧରେଇ ଦେଲା ବୋଲି କି ତା ଭାଇ
And that the trial court has not considered that.
ଅନ୍ୟ ସାକ୍ଷୀ ଗୁଡା କଣ
Honestly, ସମସ୍ତେ hearsay, my lord. Those who have rushed to the house.
ପରେ ଆସିଛନ୍ତି
ଯୋଉମାନେ ପରେ ଆସିକି ଦେଖିଛନ୍ତି deceased lying dead, my lord. Or heard from the PW11.
ବର୍ଷ ରହିଲାଣି
Ma'am, since 28/4/2012, more than 12 years, my lord.
PRL number 70 of 2020. The appellant, Lochun Udawa, faced trial in the court of London Sessions Judge Devar in ST case number 22 of 2012 for offense punishable under section 302 of the Indian Penal Code on the accusation that on 27/4/2012 at about 5 p.m. at village Mahasindhu bracket Sunakosi, he committed murder of Jogi Bag bracket hereafter the deceased. The London Trial Court by judgment and order dated 2010-2017 found the appellant guilty of the offense charged and sentenced him to undergo RI for life and to pay fine of rupees 500, in default to undergo RI for 1 year. Stop. The prosecution case, as per the first information report lodged by PW11 Sambari Bag.
না এটা ইয়ে দিচ্ছে মানে দুসিয়া দিচ্ছে
somebody back.
সাম্বারে দিচ্ছে
Sambari Bag, the wife of the deceased before the, who is the IO?
IO man, there are two IOs.
No, initial IOTA. PW15 now.
PW15.
Acha. Before the IIC, Kundegula police station, in short is that on 27/4,
he received it.
On 27/4/2012 in the afternoon, the deceased had been to the house of the appellant, who was the brother-in-law of the deceased. After half an hour, the appellant, the deceased, and one Inku Rajahans, the Rajahans came back to the house of the informant and sat on the veranda of their house. Inku Rajahans was in love with the daughter of the elder brother-in-law of the informant, namely Kulha Bag. KOLHA Bag, Kulha Bag, bracket PW5, and married her, for which the family members were not liking Inku. The appellant had assured Inku to provide a piece of land for the construction of the house. Hearing this, the deceased asked the appellant as to why he gave such assurance to Inku Rajans. And over this issue, there was hot exchange of words between the appellant and the deceased. The appellant and Inku Rajans left the house of the informant, and the deceased sat under the trees of a mohular tree and was
engaged in bundling the
binding
candle leaf.
candle leaves. Stop. After some time, the appellant came with a tangia and threatened the deceased to kill. The appellant, the deceased, was forbidding the appellant not to create disturbance. At that point of time, the informant bracket PW111 was returning home after carrying water from the tube well. And when she marked the appellant was holding tangia, she ran towards the appellant and took away and snatched away the tangia from the hands of the appellant. At that point of time, the appellant dealt blows on the head of the deceased by a stick. For which the deceased sustained bleeding injuries on his head and fell down on the ground. Hearing the PW11 raised south, for which PW1, the younger brother-in-law of younger brother of the deceased, rushed to the spot, and the informant handed over the tangia to PW1. Stop. And then she took her husband, bracketed deceased, to the house and allow him to sleep on a cot. And guarded him. There was profuse bleeding from the wound of the deceased. However, the deceased could not be taken to the hospital immediately, as there was no facility or vehicle for communication. And at about 4 a.m. in the early morning, when there was no response from the deceased, the informant, bracketed PW11, called PW1, PW5, and others. And all of them came and found the deceased had already died. Deceased dead for them. After receipt of the on the oral version, on the oral report of the informant PW11, one Narottam Pradhan examination.
PW6, my lord.
PW6 Narottam Pradhan scribed the written report, and accordingly the same was lost. PW 15 ना साक्षीरा जो आयोटा
initial IO PW 15
and the IIC on receipt of the written report registered Kundhigola PS case number 32 dated 28/4/2012 under section 302 of the Indian Penal Code and directed PW 15 Sivo Narayan Bhadra, the SI of police of Kundegala police station to investigate the matter. During course of investigation, PW 15 examined material witnesses and he also visited the spot, prepared the spot map, bracket exhibit 12. Stop. He held inquest over the dead body and prepared inquest report exhibit 1. He dispatched the dead body for post-mortem examination through constable. The IO seized one iron axe having wooden handle on production of the informant in presence of the witnesses and seized the same as per seizure list exhibit 4/1. He also seized the bloodstain art, sample art from the spot in presence of the witnesses as per seizure list exhibit 2. The appellant was apprehended by the IO on the same day, say on 28/4/2012, and at his instance, on the basis of his statement, the weapon of offense, that is the stick, was recovered from its concealed position under the dried fence of his house and under section 27 of the Evidence Act. This is the statement recorded on the section. And it was seized as per seizure list exhibit 9 by exhibit 9 along with the rose color lungi with white pant, rose and black color t-shirt on production by the appellant. The IO sees the wearing apparels of the deceased, which were produced before him after the post-mortem examination by the constable as per seizure list exhibit 10. He also sent the appellant to the medical officer Kundhigola PHC for medical examination and you also see the nail clippings, blood sample, etc. after the medical examination of the appellant under seizure list exhibit 11. He sent the weapon of offense bracket stick to DHS Devgarh for examination and to give opinion, and also made a prayer for the learned SDGM Devgarh to send the seized exhibits to RFSL Sambalpur. And accordingly, the exhibits were forwarded. On 29/5/2012, he sent a requisition to Tahsildar Riyamal to demarcate the land where the dead body was lying and handed over the charge of investigation to IIC Kundheigala Police Station. Who is that IIC? Second IO?
PW16, my lord.
And
Plus N.
bracket range PW16, who after taking over charge of investigation received the report from the Tahsildar Riyamal and on completion of investigation submitted charge sheet against the appellant under section 302 of the Indian Penal. After receipt of the charge sheet, the case was committed to the Court of Session following due procedure, where the charge was framed against the appellant. The appellant pleaded not guilty and claimed to be tried, for which sessions trial procedure was resorted to establish his guilt. Stop. In order to prove its case, the prosecution examined 16 witnesses. The prosecution also took 16 documents and also took 4 material objects. The defense plea is one of denial, and it is stated that the deceased died on account of taking liquor. The London trial court, after assessing the oral as well as documentary evidence on record, came to hold that PW11 is the only eyewitness to the case, who had opportunity to see the second episode because she claimed faced water from the nearby tube well. Then trial court accepted the evidence of PW11 and PW1 that the assault on the deceased was made by means of a stick punch on a body. The evidence of PW5 relating to the oral dying declaration has been deliberated by the learned trial court. The learned trial court also accepted the evidence of leading to discovery of the stick the functional body are the instance of the appellant. And holding that PW11 is a fully reliable witness and his evidence is getting corroboration from the medical evidence. Then trial court found the appellant guilty under section 302 of the Indian Penal Code. Mr. Rakesh Behra, learned counsel for the appellant, submitted that the evidence of the sole eyewitness PW11 would indicate that there was hot exchange of words between the deceased and the appellant prior to the assault. And even though the deceased was earlier armed with a sharp cutting weapon like axe, but he did not give any blow to the deceased with such axe, and after the same was taken out by the informant, it appears that only one fatal blow has been given on the head of the deceased. The learned counsel submits that the deceased was not taken to the hospital after the occurrence, and he was found dead in the 4 o'clock in the morning of 28/4/2012, and taking into account the background of the case and the fact that there was good relationship between the appellant and the deceased prior to the occurrence, and the quarrel happened all on a sudden when the deceased came to know that the appellant assured uh, uh, one Inku Rajhans, who was in love with his elder brother's daughter and married him without the consent of the family, and to give him a piece of land for construction of the house, and single blow was given. Therefore, it can be said that it comes within the exception provided under section so and so, and the therefore the conviction of the appellant should be altered from one under section 302 IPC 304 Part 1 of the Indian Penal Code. The Land Council submits that the appellant is in custody for more than 12 years, and therefore the sentence be reduced uh, to period already under law. The Land Council for the state, on the other hand, supported the impugned judgment and submitted that the Land Trial Court has rightly placed reliance on the evidence of PW 11, the wife of the deceased, and he has specifically stated how the appellant dealt the blow by means of a stick on the head of the husband. Land Council further submits that the evidence of PW1 also corroborates the evidence of PW11, so also the medical evidence. He argued that the lacerated wound which was found on the left parietal region, according to the doctor, bracket PW9, was sufficient in ordinary course of nature to cause death of the deceased, and therefore the Land Trial Court is quite justified in convicting the appellant under section 302 of the Indian Penal Code. After adverting to the contention raised by the Land Council for the respective parties, let us first see whether the prosecution has successfully established that the deceased met with a homicidal death or not. Apart from the inquest report, it appears that PW9, the medical officer attached to District Headquarters Hospital, Deoghar, conducted post-mortem examination over the dead body of the deceased on 28 to 2012, and he noticed the following external injuries. Quote for the 1 to 4. He further stated that on dissection, he found a hematoma of size 5 inch into 4 inch over the left parietal temporal region. There was linear fracture of left parietal bone of 1.5 plane, and the injury were opined to be antemortem in nature. The cause of death was due to head injury and hemorrhage, possible by hard and blunt object. And time of death was within 24 hours of the post-mortem examination. The doctor proved the PM report, which is marked as Exhibit 5. He also examined the weapon of offense, which was sent to him by the IO with a query regarding the possibility of the injury sustained by the deceased with such weapon. And he opined it in affirmative and further stated that the injury is sufficient in ordinary course of nature to cause death. Stop. The in view of the evidence, in view of the inquest report, the postmortem report finding, the evidence of the doctor bracketry PW9, which has remained unchallenged in the cross-examination, we are of the view that the London trial court is quite justified in holding that the prosecution has successfully proved that the deceased met with a homicidal death. Now coming to the evidence of PW11, with the eyewitness to the occurrence and wife of the deceased, she has stated that on the date of occurrence, the appellant promised to give homestead land to Inku, who had kidnapped the deceased elder brother's daughter. Stop. She further stated that after the appellant left the house, the deceased was bundling Hindu leaves and she had been to fetch water, and at that time the appellant came from his house with an axe in his hand and was killing Mari Devi and ran towards the appellant. Stop. PW11 stated that seeing the appellant running towards the deceased, he threw the water and ran towards him. And when the appellant was about to give a blow, he raised the hand and snatched away the axe from the hand of the appellant. He further stated that both the appellant and her husband bracket deceased tussled with each other. He further stated that at that point of time, the wife of the appellant was standing near there with one stick in her hand and handed over the same to the appellant. And getting the stick, the appellant dealt a blow on the head of the deceased, for which there was profuse bleeding stopped. PW11 called the younger brother of the deceased, namely Dacia bracket PW1, who came to the spot and snatched away and took away the axe from the hands of PW11. The deceased fell down at the spot, whereafter the appellant left the spot, leaving with the stick. The deceased, he further stated that they took the deceased to the house and laid him over a mat on the ground. And as it was a night time, the deceased could not be taken to the hospital. He further stated that at about dawn time, she found profuse bleeding from the nostrils of the deceased, and called PW1. So also the elder brother of the deceased who came and suspected the deceased to be dead. The doctor was called for, and on checking the deceased, he declared the death of the deceased. In the cross-examination, PW11 has stated that the appellant promised to give homestead land to the husband of Panchali, who was the daughter of the elder brother of the deceased, to help them settle down. And the appellant tried to persuade the deceased and the elder brother of the deceased, so also the younger brother of the deceased, to cooperate with him to help Inku and Panchali settle down as per his assistance. She further stated that her husband and Lochian exchanged hot words with each other. In view of the evidence on record, it appears that prior to the occurrence, on account of the assurance given by the appellant to provide a piece of land to Inku, who married to Panchali, the elder brother's daughter of the deceased, there was hot exchange of words between the appellant and the deceased, and there was also tussle it further appears that the appellant was, even though armed with an axe, had not assaulted with such axe to the deceased. The assault on the deceased took place with a lathi which was handed over to him by his wife. Nothing further has been brought out in the cross-examination to disbelieve the evidence of PW 11, and her evidence appears to be reliable and trustworthy. Moreover, his evidence is getting corroboration from the evidence of PW1, who is none else than the younger brother of the deceased. He has stated that while he was bundling the kendu leaves in his house at about 4 p.m. to 4:30 p.m. in the afternoon, he heard sound uh, and when he came out of the house, he saw the deceased is falling down on the ground with bleeding injury, and he also found the appellant was standing near the deceased with a stick in his hands. Thereafter, the informant bracket PW11 lifted the deceased and due to want of conveyance, the deceased could not be taken to any hospital, and in the night, the deceased breathed his last. He further stated that the deceased and the appellant were pulling on well with each other prior to the commission of the occurrence. However, he expressed his ignorance as to the real reason for which the appellant assaulted the deceased on that day. He further stated in the cross-examination that had they taken the deceased immediately to the hospital, the chance of survival of the deceased was there. Stop. The evidence of the doctor also corroborates the evidence of PW11.
Having appeared immediately.
The
evidence can be taken as rejected.
PW6.
No, one.
The evidence of PW1 is also relevant as it not only corroborates the evidence of PW11, but it also indicates about the presence of the appellant at the scene of occurrence while the deceased was lying injured on the ground. Stop. The
can be taken as rejected.
this can be taken as the res gesti under section 6 of the Evidence Act. The evidence of the doctor bracket ray PW9 also corroborates the evidence of the PW11. He has found the lacerated wound on the left parietal region and further stated that the said injury was possible by the weapon which was produced before him. Stop. The investigating officer, the investigating officer, bracket ray PW15, has stated that while the appellant was in custody, he uh, gave his statement, which was recorded under Section 27 of the Evidence Act, and he laid the police and other witnesses near
gave recovery of
the dried fence around his house and brought out the stick from the dried fence and produced before him, which was seized as per seizure list exhibit 9/2. The recovery of the weapon of offense at the instance of the appellant and the positive opinion given by the doctor, bracket PW9, therefore corroborates the evidence of PW9. Therefore, in view of the available material on record, we are of the view that the prosecution has. I would like to the said stick was sent for chemical examination, and human blood was noticed as per the C report exhibit 16/1. The in view of the available material on record, we are of the view that the prosecution has successfully established that due to the assault of the appellant by stick, bracket ray MO MO1, comma, the deceased sustained head injury, which ultimately resulted in his death. Coming to the contention of the land counsel for the petitioner, that the there was that prior to the occurrence, there was good relationship taking into account. It appears that there was good relationship between the appellant and the deceased, as stated by PW1, and he is also the brother-in-law of the appellant, of the deceased. It further appears that the appellant was trying to settle the dispute between that the dissension which arose on account of the elopement of the daughter, on elopement of the elder brother of the deceased with one Inku Rajans, and getting married to him against the will and consent of the family, and the appellant trying to provide a piece of land to them for construction of the house, which was not approved by the deceased, for which there was quarrel between the two. It further appears that the appellant, even though armed with a deadly weapon like axe and had sufficient time to assault the deceased, did not use the same. and he only used a stick bracket, a puncheon body, and dealt only one blow on the head of the deceased. And the it further appears from the evidence on record that the deceased could not be shifted to the hospital immediately for treatment, uh, and ultimately he died
in absence of it. In absence of a medical
in absence of the
Immediate
immediate medical treatment. In view of the background of the case, and since the occurrence happened on account of a sudden quarrel between the parties, taking into account the overact committed by the appellant, we are of the view that the uh, conviction of the appellant under section 302 IPC cannot be sustained in the eye of law. The case squarely comes under the exception to section 300, and it comes within that culpable homicide not amounting to murder. But since the appellant has assaulted on a vital part of the body and fracture of the skull bone has been caused, it can be said that it amounts to culpable homicide, not amounting to murder with intention.
Yes.
Therefore, the conviction is to be altered to one under section 304, part 1 of the Indian Penal Code. And we imposed the sentence of RI for 10 years to the appellant, since the appellant is already in custody, as stated by the land counsel for the appellant, for 12 years. He shall be released forthwith from jail custody if his detention is not required in any other case. The appeal is accordingly partly allowed for them. Partly put a note of appreciation. Upon कौन decision ଦେଇଥିଲେ परा?
मैं
देखिलो. ये जो altered କରିବା ପାଇଁ ତ?
मैं
The land counsel for the appellant
flag the decisions.
placed reliance on एगुड़ा देखी देखी important line गुड़ा को read करेगा है ना?
And I have consent memo also I have tried.
हाँ. The प्रथम देखी देवे. The Mr. So-and-so files the consent memo given by Mr. Parik Sarutinai, which is taken on record.
Item 17 Miller. In this case, I am the petitioner of the
17.
17. Now I am the legal advice.
17.
My lord. In this case, we are engaged as appellant lawyers now in this side.
Okay. Legal Services Committee को टी inform खाली कर देगी, we will engage another. 80 दे देवे, 80 लेखाटे दे देवे. In view of my engagement in the government penal.
Some other lawyer may
maybe.
coming. Aji दे जो तो अभी का दे दो, है ना?
Oh.
One should engage that will engage.
Mr. Nanda is there.
Files a memo that is now in the panel of application, and we request the panel of the engage. But they don't know memo is taken on the one should engage. तो कालिका ପାଇଁ ଆଉ ଗୋଟେ matter ଦେଖନ୍ତୁ କିଏ ready ଥିବେ, ହେଲା?
ଆପଣ କିଛି ଅଛି ଖାଲି କିଛି ଏଇ କେସଟା ନେଇ ଯାଉନା
କୋଉଟା
ତାଙ୍କର କିଛି ନାହିଁ କାଲି ମିସ୍ ନନ୍ଦା ଇଜ ହିୟର
କାଲି
can you get ready tomorrow she is not ନାହିଁ ହବନି ହବନି ତାପରେ 302 matter
302 ଗୋଟେ ସପ୍ତାହ କମ ସେ କମ ଦବା କଥା। ତେଣୁ ଆଜି ଆମେ ଏନଗେଜ କରିକି ଏ ଲିଷ୍ଟରୁ ଆଉଟ୍ କରିଦଉଛୁ, ନେକ୍ସଟ ୱିକ ରେ ଆସିବ ୱିଲ୍ ଏନଗେଜ। ତେଣୁ ଆଉ ଗୋଟେ ଜଣକୁ ଦେଖନ୍ତୁ ଯାହାଙ୍କର ନାଁ ଅଛି ଯିଏ ପ୍ରିପେୟାର ହେଇଛି। अमाइकस क्यूरी आम एंगेज करछु एटी गोटे 22 नंबर रे काहकु
ସେଇଥିରେ ମିସ୍ ସସ୍ମିତା ଦାସ କିଏ ଆସିଥିଲେ? ସରିତା ଦାସ।
ଦୀପକ ସାହୁ ରୀତା ସିଂ ଫୋନ କରି କହିଦଉଛୁ।
ଏଇଟା କିଏ ଆଗ୍ରହୀ? ସରିତା ଦାସ
21, 22 item.
ଏଇଟାରେ ଥିଲେ ଏଇଟାରେ ନାଇଁ ଏଇଟା ଆଉ ଗୋଟେ ଏଇଟା କାହାଟା ଏଇଥିରେ ଆଗରୁ ବୋଧେ ହଁ ନାଇଁ ଯୋଉ 17 ଯୋଉଟା ସେ କହୁଛନ୍ତି ଜଳେଶ୍ୱର ନାୟକ ମିସ୍ ସରିତା ଦାସ
जटेश्वर नायक तो एंगेज कराइतला बोले
हाँ
सीधा बोले पावर बाय
ये हाँ
पावर के मिश्र फाइल करले एलियर दियारे 8 रे फाइल करले
हां अपन पावर फाइल करते
ଆପଣ ନାଇଁ ଆପଣ ପ୍ରାଇଭେଟ ଥିଲେ ଆଉ ୱିଲ୍ ଏନଗେଜ ନା
ये जो पूरी सरिता दास सरिता दास की
ସେ ନଥିବ ବୋଧେ ଆଉ ତାପରେ ଆପଣ ଆସିଥିଲେ ଆଫ୍ଟର ସରିତା ଦାସ ଜଟେଶ୍ୱର ନାୟକ ଲ୍ୟାଣ୍ଡ ଠିକ ଅଛି ବୋଲି